advisor on the submissions that were made and the process that we're going to engage on henceforth. We've removed one item. The reasons that we have, if you check these items which are on the agenda, we probably need sufficient time to interact with them. And Mr. Matonsi, I think we're going to be more strict in terms of the key issues that we must deal with, given the time that were allocated and to afford members to interact with these presentations. More interest maybe all the issues that are raised, and we must give members enough time to interact with, and other issues will then refer them to future sitting if are not exhausted in this meeting. I'm not going to waste time, going to allow Mr. Matonsi to do introduction. Can the leader of delegation, it may be important, and apologies if I'm going to be carried, then I'll invite the minister to. Thank you, Mr. Matonsi.
Yes, Chairperson, from my side, the apologies is from Ms. Kanyile. She won't be joining the meeting, and then there will be a late joining of the meeting by Ms. Tito. She said she will be joining around 10 o'clock. She's in a flight down to Cape Town. And then, so I'm not sure, Chairperson, whether I should request the UNHCR and the Congolese just to introduce themselves, or you're going to do that?
Yes,
good morning.
You can do that. Thank you, Mr. Matonsi.
Yes, already. I think the UN representative was already online just to introduce, if they can do that, and then followed by the Congolese. That will be all for me.
Okay. Good morning. Good morning, Mr. Shabani. Good morning, everyone. My name is Igor Chobano. I'm Deputy Representative for South Africa Multi-Country Office. With me in the room, it's Senior Protection Officer, Jesus Sanchez Spencer. Thank you.
Mr. Matonsi, we're still on your platform.
Yes, Mr. Mumbilo, can you please introduce your delegation from the Congolese Society or Civil Society of South Africa?
Thank you very much, Chair and Eddie. My name is Isaiah Mumbilo. I'm the chairperson of the Congolese Civil Society of South Africa. I'm with Kati, who's representing Kopanang, and also Kispen going to join us later. Thank you very much.
Thanks, Chairperson. That is all from my side.
Okay, thank you, Mr. Matonsi. Mr. Matonsi, can you, I hope the department are here, if I can get an understanding, if the minister is here, or the DM, or the DG.
Yeah, both the minister, the DG, and the deputy minister, if I'm not mistaken, they are in the meeting.
Okay, thank you. Can you take us through on the item number, the next item, so that the members understand why, or those are in the meeting?
Okay, Chairperson, with regard to the Congolese civil society, on Human Rights Day and also on Refugee Day, they marched to Parliament to submit a memorandum to the Speaker. So those two memorandums were also forwarded to the committee so that we can deal with the issues. That's how we came to have the Congolese Civil Society of South Africa to this meeting today. This is in response to the memorandum that was sent by the Speaker to the committee, Chairperson.
Okay, thank you very much. The reason I think outlined by Mr. Matonsi is correct that there's a memo which was sent to the Speaker, and the Speaker did refer the item to be entertained by Home Affairs Portfolio Committee. Hence, this item has been brought before our attention, and an invitation was sought extended to this civil society for us to listen to what are the issues. Then what is going to happen is that we'll not, and I want to be clearer in terms of structuring the issues which are going to be dealt with. One is that the minister is not going to be, or the DM or Home Affairs are not going to be made to respond on this item in this meeting. The Congolese civil society had requested an audience which they've been provided. They will then present, and the members will interact with the report. It may be important to note that this report, it will be given a particular time, but this meeting will note it. I'm raising it because we're having here the United Nations High Commissioner for Refugees, the Department of Home Affairs, the Minister, the DM and the DG. And I'm cautioning that they are not invited to respond to the issues that are going to be raised in this meeting. If there are issues that need to be dealt with in relation to the memorandum, the committee later will deliberate and refer matters to the Department of Home Affairs. Is how we're going to deal with this item. Can I invite Mr. Matonsi, the head of delegation? We must be aware that there's a sitting at 2 o'clock, and members may need to go to to attend the sitting at 2 o'clock. And as I've indicated, that time is not on our side. Let's talk to the presentation, key issues which are there, noting that the report has been circulated to members, they've gone through it, and therefore we move to other items. All the presenters that are going to present caution that we are dealing with the time constraints and issues of our interest as members of the committee. You may need to talk to them. Mr. Matonzi, can I invite the civil society to present? Thank you.
Hi, Mr. Mombilo, can you please present? I've given you the right to share your presentation.
Thank you very much, Mr. Eddy. Thank you, Chair, for this privilege you're giving to us for this report of the combined recommendation of our memorandum, which was so important on the Human Rights Day and the Refugee Day on 2022. We really appreciate, and we give thanks also to the Speaker of the Assembly. And we thanks also all the follower which going to follow our presentation. As you can see, there's some content of our presentation, which I can pass for just saving time. So we're going to touch on the introduction, which is something very important. We're going to understand why we're making this presentation. We, the victim of the failure of Pan-Africanism since the end of colonization, for a national living in South Africa, we found refuge in South Africa called by the name In the Soil of Africa and the victim of apartheid. Citizen of South Africa who believe in Ubuntu despite the influence of separatism, who believe in the same root we all come from as African. We motivate in the belief that the Human Rights and Refugee Days of 2022 are days of defending our Africanism, came together in the 2 marches for human rights and the right of a refugee in South Africa, promoting the value of diversity and solidarity of organization, which is mentioned under like Housing Assembly, Calabrini, Kopanang, Unifarm, Congolese Civil Society, and so. as a collective initiative toward long-lasting, peaceful coexistence and a sustainable social cohesion between refugee, asylum seeker, migrants, and the local host community in the Western Cape province in particular, and in the Republic at large. Human rights, refugee, asylum seeker, and immigrant in South Africa. The unjust and unequal society which African politicians create for control of power and ongoing banalization of a black person as the only weak target when the issue of refugee foreigners has been raised nationally, which change our identity as a refugee, asylum seeker, and immigrant, victimize us Black African in South Africa with the promotion of a normation of xenophobia, where Black foreigners are witnessing themselves how their concern has been the key of statement from South African politicians and the reason of South African misery. The loss of a human rights ideology on Black foreigners in South Africa, refugee, asylum seekers, and migrants. It has been proven that the recognition of refugee, asylum seeker, and migrant in South Africa lost 48% of its human value when a decision is about to be made against foreigners, mostly for approving how they can be just accepted as human, who is being part of the human race, who deserve to be heard for just by being part of our humanity. Foreigner child is considered like a refugee, not as a feature of our humanity and a better Africa. Political statement and violation of refugee rights and immigrants are raised very high. Between 2004 and 2008, violation was very low compared to 2008 until 2022, which is in nowadays like a common thing. It's no longer a sensitive issue to avoid, to allow, but we believe that South Africa is not xenophobic. We do believe on that. But we have seen since 2008, action against foreigners, even in state institutions. We have no idea what can we call it, as we believe no South African are xenophobic. The work of International Convention for Refugee, Asylum Seeker, and Migrant in Durban, in order to rescue the victim of African politician and rebellion, who are today being called refugee, asylum seeker, and migrant in South Africa, the work of international relevant convention and the treaties that guarantee and promote refugee, asylum seeker, and migrants' rights, which South Africa signed and ratified, provide a period of a political will to promote South Africa as one of the best conservators of Ubuntu spirit on this first decency since the signature of international convention and the treaties. South Africa introduced an anti-migrant isolation system in contrast to other countries who receive African refugees. South Africa prefer the integration program than the camps, and exceptional decision as a country proud of Ubuntu and the conservatory of Ubuntu. The 1951 UN Geneva Convention and the 1967 UN New York Protocol relating to the status of refugee, and the 1969 OAU, Organization of African Unity, Convention governing the specific aspects of refugee problem in Africa are uncertain in an optimistic way to stand for refugee, asylum seeker, and migrants when they are desperately in need of any convention support from any misconduct against their rights. Statement made to be considered supportive from politicians which devaluate the reason of the convention under the circumstance where refugee, asylum seeker, and migrants are not the preference of a certain group in the host community or political parties. Attacks against foreign nationals who do not deserve to be in South Africa, according to certain local people. Guyton Mackenzie, who say he will personally walk through the hospital suite of foreign nationals oxygen machine and they put South African on those machines because the oxygen belonged to South Africa. The concern which were the illegality of foreigners tend to the mass return of all foreigners, even the legal one, stated by the Dudula movement. An undocumented human do not deserve treatment if he or she doesn't have money to pay. There was the issue of a person who's really documented with a status being arrested in Cape Town police station because of a lack of not a verification appropriate for home affairs in police station, and the person slept in police station Cape Town. One day, even the woman who was pregnant to come to bring the proper paper, and they reject the verification. And at the end of the day, Home Affairs excuse themselves to say the paper was right, where we spent already days in a police station. Notifying evidence of lack of the basic of human rights or the weak implementation of human rights value in the South African government launched the National Action Plan to combat racism, racial discrimination, xenophobia, and related intolerance, and arguably the best human rights-based and human rights-oriented constitution on earth. The implementation and the materialization of those commitments remained a major challenge across the Republic. A promotion of the National Action Plan in South Africa to combat racism, twin sister of xenophobia, racial discrimination, xenophobia, and related intolerance by the President of the Republic. This shows the convention concerning refugees are also affected, meaning evidence of possibility of no full implementation of convention which protects refugee, asylum seeker, and migrants in the circumstance of failing on international agreement. As the 18th June being declared since 2019, the International Day Against Racism, Discrimination, Xenophobia, and Violent Relates, the rise of a movement called Dula and the other who serve as a tool to push the end of the International Convention of Refugee, Asylum Seeker, and Migrants existence in South Africa by taking government institution and law to their own hand to challenge any resistance against the not living of all foreigners national in the soil of South Africa, which lead on visiting wherever foreign nationals are. South Africa approved the Durban Declaration and the program of action adopted on September 18, 2021 at the World Conference Against Racism, Racial Discrimination, Xenophobia, and Related Intolerance. You can check that in chapter 1, in particular, paragraph 2 of the declaration and the paragraph 84 to 86 of the program, as well as the relevant provision of the outcome document of the Durban Review Conference of April 24th, 2009. Check the chapter 1, in particular, paragraph 11, 13, and 54. The vote of the UN resolution 74_136 of December 1929, fighting Nazism, neo-Nazism, xenophobia, and racism, and racial discrimination. We believe that political will is the key to solve the fear caused by anti-African movement. International Convention under Forced Adjustment. The convention enables refugee, asylum seeker, and migrant to have a second home for the sake of second chance of life as any human deserve when their human value is under threat. South Africa, the land of no fear, to live in as South African Constitution also secure whoever live in South Africa as the same right equally. South Africa was more an advocate for foreigners in Africa, and now it sounds like a judge who cannot stop strongly the local group and the politician who are making the living condition of foreigners national in fear. The illegal are blamed, and the legal one are also under the pressure to leave the country. The challenge of foreigners sound more against illegal officially, but the pressure of the ground is for all foreigners, even the legal one. You can see reality of foreigners, illegal or legal experience of fear to reside in South Africa at working place, hospital, bank, street, public transport, and community. Immigration law being reviewed so many times up to now to pressure the illegal and to leave the legal one with no hope to survive in South Africa, even all paperwork is correct. The safety which was created by the International Convention is being removed slowly because new implementation of a new law in all sections concerning foreigners in general. The vulnerable race who are victims because of the immigration law change are immigration law change are Black African who supposed to be the less vulnerable in any challenge against foreigners in South Africa because they are the son of African who've been victimized since slavery, colonization, neo-colonization, and apartheid. It lists under the leadership of Black African, Blacks cannot be the first class of victim when it's about the right of the African land. Next page. Illegality caused by the service provider. The service provided by refugee center is also the main cause of the illegality of foreigner. Final decision can be based on incorrect translation by the select interpreter who's not accountable and not independent organization for translation. Verification is available, not even an appeal board. Stateless children are increasing every year without any future decision based in the value of a human right to give our African children in South Africa a way out for their participation in the program of the Agenda 26.3, which is no longer promoted strongly as it started. The gap of timing between the request of asylum seeker and the final decision, which can take 10 to 15 years, during which time an applicant can already have a family, and being declared illegal when he's already old, with big responsibility under the challenge of losing his job because the declaration of his illegality. It's easier for an applicant to return when he or she is a newcomer than after years of living in South Africa. The illegality of children who are born in South Africa because of the very late rejection of a parent's document, children to be forced to lose their education, which is needed in our continent for global progress, battle against illegality migrants. Legality of online refugee and asylum seeker, which are not recognized in certain working place and the police station. Home Affairs quality of service, speed, reduction in the waiting time for decision, consideration of the situation of a couple in which one of the parents is illegal, taking into account the situation of children, etc., etc. Self-passage requests and recommendation. The current situation requires a safe passage plan for better South Africa, which we always want. Dealing with illegal accordingly by not letting power to be out of government institution hands. Reviving the value of international convention, creating a safe environment for legal foreigners who are part of economic growth and the African right to be. Making the refugee center and the immigration service more efficient because of the huge delay of service increase the illegality of refugee and asylum seeker. South Africa as refugee host state is in a better position to assist, preferably via regional, like SADC, ECOWAS, etc., and the continental AU mechanism toward having human rights based and a human rights oriented democratic governance institution in those African refugees sending country in order to reach, negotiate term of and condition for voluntary repatriation of those African refugees as the one most preferable durable solution to the refugee problem in Africa. We strongly wish to highlight that the negotiated term of condition that ought to be facilitated or at least initiate, support, and possibly sponsored by South Africa as currently the top priority of African asylum seeker destination via regional and continental relevant mechanisms will also provide for reintegration and rehabilitation of those African refugees back in their homeland to have an opportunity to contribute to social, cultural, socio-economic, and socio-political initiative of their home country. Most African refugees sending countries to South Africa have dictatorial repressive regime and or internal politically induced war in contrast to externally imposed war, which force their citizens into exile to South Africa. Those countries are characterized by gross violation of basic and fundamental human rights, a lack of democratic practice, and public social policies. Negotiate terms and conditions for voluntary repatriation will work for the best interest of South Africa's local community as revolves over scarce resources between local citizens and more particularly African immigrants will be substantially cut off. In the best interest of both local South African and African immigrants, we request the implementation of the white paper on international migrations for South Africa, Home Affairs 2017, using a proactive approach, which will entail engaging and challenging those African refugees sending country to put in place multi-party system and effective democratic mechanism as stated by the subsection Management of Refugee and Asylum Seekers on page 60 of the above white paper. Absolutely, not only strong, effective, and conducive human rights-based and human rights-oriented democratic mechanism will progressively keep African people inside their homeland, but also it will motivate strongly, encourage, and enable the majority of African refugees in South Africa, in not all, if not all, to subscribe to voluntary repatriation back to their respective home country under negotiated terms and conditions for integration into their respective national society and rehabilitation into their respective socio-cultural group once back home. Other African migrant, refugee, and asylum seeker in South Africa will love to be in their respective homeland, contributing their best to the prosperity of their own home country, rather than being killed in South Africa, the socio-political and the socio-economic condition back home in those different African refugees sending countries are not conducive enough to safeguard their social security, cultural emancipation, legal protection, and economic prosperity. We finally plead for the reopening of the refugee reception office across the Republic and the technological problem of the online application system to be revised so that the daily volume of online application of refugee and asylum seeker can be effectively and efficiently processed. We appreciate this dialogue initiative, which allow everyone to understand the challenge and the effort made for lasting solution. We suggest that the engagement of this dialogue initiate continue. This will allow us to access progress, but also to better educate our national on progress and what remains to be done. It's by working together that we can iron out our differences. The gap and the lack of dialogue between us and the institution department are not conducive to a better way forward. We are pleading with the portfolio committee to work closely with committee leaders for improved relation between African migrant, refugee, asylum seeker, and South African for a better outcome for African migrant in South Africa. Thank you very much, Chair, for this privilege. Once again, thanks you.
Thanks very much for the presentation. There are few principles we must outline so that at least there's an appreciation of the issues we're dealing with as Parliament. The first one is that South Africa is signatories in international bodies and in areas that we're dealing with the refugees or asylum. And we're participating fully and appreciating that Parliament has, or government, they've been participating in that area. The second part is that we are governed by the Constitution as a country in any other member states, and legislation that affect the policy implementation in our spheres of government in relation to the immigration policy or immigration act. So I earlier on cautioned that we'll pay attention to the issues and will then refer for any other matter that arises from this presentation to the department. The third point is that Parliament and the department, which I can affirm that, is that we are fully in support of any other citizen or our African brothers or sisters or any other person who enter into the country or who participate in the country to fully recognize and appreciate the laws of this country. And we're in that discourse of immigration reform. Like any other resident of the or citizen, when she or he go to other countries, the expectation is that you must adhere to the rules that govern that member states. I'm just highlighting this points because we've over time received reports from the committee, and in the discourse of engagement, we've reaffirmed the appreciation for the Constitution of the Republic and any laws that governs immigration to be added to. So I wanted to start there so that it's clearer from our interaction that we have legislation that governs and the policies at the level of the departments that must be implemented to the latter. We want to thank you for just bringing these matters to our attention, but I'm going to invite members to deal with the issues. And I think the last two issues, and I can see your report raises some names of people or stakeholders. I'm sure that that may not be our view to interact in that space. And I'm sure that non-South African is xenophobic. We're all at one. And I think this is the principle of African unity, but that does not work outside what governs member states. So I'm going to invite members, if there's comment on the matters, as I've outlined, that we may consider to note the report or the presentation and we'll refer other matters, this report, to the Department of Home Affairs. I'm going to start with the Honorable Lizel, Honorable Lokhwase, Honorable Mohale, Honorable Ross, Honorable Ramolobeng, Honorable Pillay, and Honorable Mudisimza. Mr. Matonzi will advise if I might have not noted other members to comment in that order. Honorable Lizel.
Thank you very much, Chairperson, and good morning to yourself and our colleagues, the Minister, the Deputy Minister, and also our Congolese brothers who came to present this morning. I want to firstly align myself to the comments that you have made, Chairperson. Firstly, I want to thank the civil society organization for coming to us and briefing us on their issues. I think all of their issues are valid and we've taken note of them. And as you have outlined, we will refer this report to the relevant stakeholders to have a look at it and to obviously comment in due course. But I would like to say, I think what I found heartening about the presentation was the fact that the presenter mentioned the fact that firstly, South Africans are not xenophobic, because I strongly believe that South Africans aren't xenophobic, that we are a very welcoming country for migrants from all over the world and not only African migrants. And secondly, I did appreciate the fact that he mentioned that we in South Africa have not erected refugee camps at the various ports of entry, which other African countries and indeed America and Europe and other countries have established. So in fact, we do welcome asylum seekers and refugees into our country. We do allow them to integrate. However, when I was listening to the presentation, I got a bit concerned because I think two issues were conflated. Firstly, the issues of the rights of refugees and asylum seekers. And I think we must affirm the rights of refugees and asylum seekers who are within our country and within our borders legally, versus the other issue the presenter mentioned, which is the issue of illegal migration. And I want to make a comment in that regard. I want to say we as Parliament, we as a portfolio committee, we are 100% in supporting our government, our department, to ensure that the rights of migrants who are within our borders are protected and upheld, those who enter our country legally. But I must make a comment to say that, no other country in the world laws are there to curb illegal migration, and it's no different. It's the same in South Africa and across the world. So I found it a bit perturbing that we were conflating the issues of the rights of migrants and people who are within our country seeking asylum with the issue of people who are here illegally. And I think the groups that were mentioned, the people that were mentioned, as much as we talk about the rights of migrants, I think also the groups that were mentioned have got a right to protest when they see that there are people within our borders who are not complying with our laws. And so I want to really say that we as a portfolio committee do support matters of supporting the rights of migrants, but we are also as a portfolio committee concerned about people who enter our country and do break our laws, because all who are within the borders of South Africa should do so legally and should comply with the laws of the land. But thank you very much for the presentation. We have taken note of it, and thank you for your time to come to our portfolio committee to raise these issues. And it is something that we will take note of going forward. Thank you, Chair.
Thank you, Honorable Zel. Honorable Lhwase. Thank you, Honorable Mohale.
Thank you very much, Chairperson. We note the presentation from the Congolese delegation. And I must say that it's very disappointing to hear some of the things that you are mentioning, Chairperson, that, we have not made South Africa to feel safe for immigrants. Is quite unfortunate. And I think the political environment at the moment is highly charged with anti-foreign sentiments, which contributes to making our people, because these are our people, who might be divided in terms of these artificial boundaries, but they remain our people. So it's very unfortunate to hear some of the leaders in government making statements which, contribute towards a climate of fear for our fellow African brothers. And I think the minister has also been guilty of some of these statements. When we can't accept that, Chairperson. I think we all know that we come from a very terrible past wherein some of our people had to flee the country and they found refuge and accommodation in these African countries. Therefore, we can't allow a situation where fellow Africans who have run away from their respective countries because of the political situation. And what is also very interesting, Chairperson, is that, we are taking, I think government is taking a very tough stance towards immigrants currently from Zimbabwe and other parts of the African continent. But on the other hand, the very same government is cajoling these African leaders who are creating these very same problems. It's very unfortunate. So in closing, I just want to offer an apology on behalf of non-xenophobic, non-Afrophobic South Africans to our Congolese brothers, to say that we understand your situation and we'll do our level best to ensure that your rights are respected in this country. Thank you very much, Chair.
Thank you, Honorable Mohale, for your contributions. Honorable Ruas.
Thank you, Chairperson, and thank you to the presenters. Chairperson, I think Honourable Lazelle covered matters very well, in that there are both rights and responsibilities in these cases. And I think that one of the challenges that we really have is a gap between being able to engage in good faith. And in many cases, this causes animosity. So I'll give you an example of what we've seen over the last few years of so-called refugees and asylum seekers, persons gathering outside of UNHCR offices. And despite being engaged with, refusing to follow the rules of the country, of South Africa, and creating situations of animosity. And I think certainly there's an opportunity, Chair. You know, we see a number of organizations representing certain groupings, and I think there's a lot of value in looking at in those organizations trying to come together in a larger forum that can engage with ourselves, that can engage with government as well, and looking at some of the issues. Because a lot of what we talk about is always, it can be very emotional. It's very difficult to get figures and statistics. So for example, DRC, a refugee coming from DRC, to get here, you need to come through 2 different countries to get here. But next to the DRC is Uganda. And Uganda has probably, to my estimation, one of the very best refugee and asylum seeker systems in Africa. So, you know, I think we, in those forums where you have the smaller organizations in a forum that one can engage with across the board, one can start to address, you know, why are persons coming across several different countries to South Africa, where there are allegations of xenophobia, where persons inside the country are claiming that they're in danger. Why are then persons still coming here instead of going to, for example, Uganda, where anecdotally there seems to be a very receptive refugee and asylum seeker system? And to try and understand that, but also to deal with some of the diplomatic issues in terms of what is going on in the country. Because one of the things that doesn't quite marry in this presentation is there seems to be a desire to look at voluntary repatriation and how that can be facilitated. But at the same time, then there's a defense that there is internal conflict and dictatorships in the sending country that makes it dangerous to go back there. So it you know, one would think it's one or the other. As a chairperson, you know, I'd really encourage this organization to really engage with other similar organizations to try and get a broader voice and to consolidate that voice, and yes, we understand the human rights elements, but also looking at the responsibilities. For example, when refugees and asylum seekers gather outside the United Nations, there is an engagement and they refuse to go. What is their role in ensuring that that doesn't happen, that processes are not abused, that we engage in these things in a manner that is within the laws of the country, and that makes it that we, you know, that doesn't develop this animosity where we say that, you know, persons are coming in and they're breaking our laws. And I think we need to get to that point where we can have a sensible dialogue, a dialogue based on facts, where we understand from all the different organizations, where we have a representation somehow, where we look at who is coming for what reason, what is happening inside the refugee reception offices, how many applications are being rejected out of hand, what are the issues in terms of diplomacy that are not being resolved, that are stopping persons from going back, so that we can actually get somewhere, Chairperson. So that is the inputs from my side, Chair. Thank you.
Thank you, Honorable Ross, for your contributions. Honorable Ramalobe. I lost Honorable Lekwasa earlier on. Is he back? Honorable Malekwa. Honorable Pile.
Thank you very much, Chairperson. And Chair, let me first appreciate, but also join my colleagues in saying that we note this report for further deliberation and action. Chairperson, I think I firstly want to say that I would have appreciated a presentation around or a discussion and lead around the slides that we saw, more than having to read, word for word, because I think all members have received this, and it would have actually assisted us if there was some kind of lead in terms of what the main discussions were. But having said that, Chair, I think it's important for us to emphasize that we are in pursuit of or for an African unity, but respect for all our member states is absolutely central. I must also place on record, Chair, that the minister, in fact, is not guilty of anything. In fact, he implements legislation that is passed by Parliament, which is indeed informed by our people. And just in response of, I think, the last slide, Chair, just to make, I think it's important to note that all of our centers are opened, except for one where there is current renovations taking place. However, this means that the system is and the processes are moving very smoothly. We must also understand that we, during COVID, experienced certain restrictions, and hence we had to have certain have centers closed. Chair, I think also important to note is that the online system is working very well and smooth. And lastly, I think the point about school or having to be admitted at school, I have to indicate that children are allowed to at school. And I think there has been many a times where discussions have ensued between Home Affairs and the Department of Basic Education in ensuring that children are allowed to school. But Chair, I just want to say that we note this report and that we would further deliberate on it. Thank you.
Thank you, Honorable Lee, for your contributions. Honorable Modise Mta.
Thank you very much, Chair. Let me also note and appreciate the report and the presentation as it has been done. Chair, I share all the sentiments as shared by the previous speakers, and that we will note the report and it will be sent to the department for more deliberations and action. Thank you, Chair.
No, thanks, honorable members, for your contributions. It assists us to refer the issues, the report to the department, and thank also the presenters and the team that is presented to the speaker, and they refer the matter to the committee for deliberations or considerations. And I want to thanks for having considered to interact with the committee. And I'm sure that we will refer this report to the Home Affairs Department. We did not want the Home Affairs to respond on these issues. If you check the entire report, make reference of stakeholders or persons' names, and it may not be fairly correct to get into that conversation with the minister where he has no privilege of being interacted with this report. At a particular time, the minister will then respond to the committee, and we then report to the speaker on how we've interacted with these issues of the Congolese. And I must appreciate all members for having contributed and also noting this report. Thank you, the team, Congolese civil society. We'll step off this item, and thanks very much. Mr. Matonsi will then get into the second item, third item.
Yes, Chairperson, it will be the presentation by the department.
Okay. Yeah, it's now 10 o'clock already. Can I get members, if we can take all the reports, then we reflect later. I'm trying to solicit if that won't be assisting the meeting for purpose of more deliberations on all the reports, excluding the Electoral Amendment Bill later. Can I establish that if it's possible? Mr. Matons, which are the reports that you can take at once?
And if ignore the Home Affairs report and the UNHCR report, because they are basically briefing us on almost the same thing. So we can take all of them together and then we engage with them after.
Okay. Can I lobby understanding if we can take that? Honorable Mohale? Honorable Mohale?
Come again, Chair.
I'm trying to get guidance from members. If we can.
Oh yes, we can take all of them, Chairperson. I support that.
Okay, Honorable Lizel.
Agreed, Chair. Agreed.
Honorable Rose.
I support it, Chairperson.
Honorable Modise.
Agreed, Chair.
Okay, thank you very much. I think we'll take the two reports, then members will engage after that. Thank you, Minister. You can start. Thank you.
Thank you, Chair.
Sorry, I was starting with the Home Affairs, Mr. Matuns.
Yes, Chair.
Okay, thank you.
Thank you, Chairperson. Thank you, honorable members. Chairperson, we've been asked to come and present 3 reports here. The first one is the opening of refugee offices in South Africa after they were closed during the COVID, for the 2 years during the COVID pandemic until the state of disaster was lifted in April this year. We're going to be reporting to you what is being done, what are the problems, and what is outstanding. But I want you to understand, refugee offices were not closed for any political reason, as this seems to be the claim. They were closed because of the issues of COVID. In other words, I could simply say it was a force majeure, which happened in many parts of the world. As you know, borders were closed all over. It is not because Home Affairs wanted to close any refugee or asylum seekers out of South Africa. Everybody know what was happening during COVID. But now that we have opened them, we are still surprised that a call is being made to open refugee reception offices. They are open and the report is going to outline what's going on. The second presentation, and that first presentation will be made by the immigration branch of the Department of Home Affairs. I think the DDG is here. The second one is about the issue of statelessness, which has caused a lot of confusion and sometimes it gets distorted. We are trying to explain what statelessness is in as far as is defined by the United Nations High Commissioner for Refugee, but we are also bringing in the issues discussed with the United Nations High Commissioner for Refugee, the Deputy Commissioner responsible for protection, Ms. Gillian Triggs, on the 25th of January, where these issues were discussed and clarified because people seem to be sort of confusing them, the issue of statelessness and what South Africa is doing about that. Then lastly, the longest of the report, and I must warn, is very long because members need to have that information, is the issue of the Backlog project. And I must also try to explain what the Backlog is about. There's a common belief that Home Affairs has got the backlog on the processing of all refugees and asylum seekers in the country. and that is not necessarily so, Chairperson. We don't have a backlog on people who are coming in for the first time to demand or apply for asylum. The backlog, as you'll see from the presentation, is people who have been rejected already are on appeal. In other words, people who have been processed in terms of the United Nations Convention of 1951, in terms of the United Nations Protocol of 1967, in terms of the Organization of African Unity Convention of 1969, and indeed, in terms of the domestication of those international conventions in our law in 1998, the Refugee Act of 1998. In terms of that, people who come here asking for asylum or refugee, they get processed. And after processing whatever the answer is, then they start an appeal process, which I must state is over-elaborate in our country. And for that reason, there is a very big backlog on that because it's an unending appeal process. Having noticed this, we have had a meeting with the United Nations Convention for Refugees, and we need to thank them. And we agreed on a joint plan, which is funded by the United Nations, as you'll see, on how to deal with that backlog. So this presentation is going to be about that. And I'll start first by introducing the DDG for Immigration, Ms. Yusuf Simons, to present to you on the opening of refugee offices in the country. Then I'll come back and introduce the second speaker and then the last one. Thank you very much.
Thank you, Minister. DDG Simons.
Thank you very much, Honorable Chairperson. Good morning, Honorable Chair. Good morning, Honorable members. Good morning also to the Minister and Deputy Minister and DG. Chair, the presentation is very short, eight slides. So the first slide deals with the number of offices we currently operate, Chair, and members. As the members would know that we operate from 5 refugee centers countrywide in Durban, Pretoria, Gqeberha, Musina, and Cape Town currently. And over the COVID-19 period, Chair, all of these offices were closed for a period of 2 years. But over this period, Chair, Minister also issued a directive that extended the period and the asylum permits for refugees and asylum seekers over that period. And in April 2021, the department then introduced an online solution to work parallel with the directive, Chair. This is where your asylum seekers and refugees actually required permits to conduct their work, study, etc. So these services that were then introduced in April 2021 related to permit extensions, collection of decisions, referral for finalization of claims, as well as importantly, Chair and members, IDs and travel documents for matriculant refugee minors, as well as persons who wish to take up employments. That is part of the background for this presentation, Chair. The next slide speaks then to the services that's currently provided at refugee reception offices. From 3rd of May 2022, Chair, all refugee centers across the country have started to operate fully, except Cape Town Regional Refugee Center. And that is only for newcomer applications, Chair. As the members would know, that the Cape Town Refugee Center is currently being refurbished. The refurbishment is completed, will be completed by the end of this month, and handover of the site will be done to the department by the end of September this month. But current services that continue, Chair, is the extension of the applications for permit extensions. That's just done online through an automated system that continues. And where clients do struggle with the system, if there are struggles with the system, Chair, they are invited to come into the office where we will assist them on appointment basis to finalize their application for extension. Chair, the next slide just speaks about statistics. And this shows how the system really is working, the online system, Chair. So the next slide, slide 5, if that can be displayed, Chair. Slide 5 summarizes the statistics for a month, for 7-month period from 1
Chairperson,
January.
the slides are not moving. Is it on my side? I'm sorry, Chairperson. Yeah, thank you.
Thank you, Minister. So this is the period, Chair. If we can just go one slide back to slide number 5. Chair, this is an important slide for the members and yourself to know, Chair. So for a 7-month period, the online system that we are currently using serviced 87,478 persons. Chair, majority of that was for extension of Section 24 permit, which is for refugees, and Section 22 permit, which is for asylum seekers. 43,000, more than half, or half of that, Chair, was for extension of Section 22 permits, which were all done online, Chair. So the system for us is working, and that's the numbers that can justify why I'm saying it's working, Chair. And I must also indicate these numbers come from our NIST system, our refugee system, so it can be audited, Chair. Thank you. The next slide. The next slide speaks to the newcomer services, Chair. And this is the first instant applicants. So from 3rd of May, as I indicated, when the center opened, and during the lockdown period, we had no newcomer services. But when the centers opened on the 3rd of May this year, we estimated, and this is statistics over the years, Chair, that we can expect 40,000 newcomers to visit our refugee centers. We then had engagements with the UNHCR in January at a high level bilateral, and we agreed that what's going to be needed, Chair and members, is a solution that the department need to develop to assist in managing this high numbers that were going to come to our offices. So on 3rd of May, when we opened all our offices, Chair, we also launched a system for the newcomers, because we knew the returns were going to be in bigger numbers. So since resumption of our newcomers services, the department has processed 4,218 newcomers already, Chair, and has 9,057 booked for future dates. These stats is at the end of July 2022, Chair.
Recording stopped.
The next slide speaks about what we need to do moving forward in managing this demand that's placed on us because of the 2-year period, as Minister indicated, that we were closed during the COVID period. Chair.
Recording in progress.
Just go back to slide number 7. Thank you. So because of the backlog that was building over the last 2 years, Chair, we had to put in a recovery plan, because we have to look at the risks of overcrowding and how do we manage that. So we will continue, number one, we will continue with the online extensions to reduce the volumes of clients that need to visit our office. So that's very important. We want to prevent these long queues, unending queues around our refugee centers, Chair. Secondly, we also received funding this financial year to appoint additional capacity at refugee reception centers. And in total, it's about 28 posts that we're in the process of filling. Many of them we have filled already. And importantly, on slide 7, importantly, the office manager of Gqeberha and the Cape Town office is also included in that capacity that we'll be filling now, Chair. What's also included there, Chair, is inspectorate positions at both Musina and Durban refugee centers. Then thirdly, Chair, we will prioritize, because Cape Town Refugee Center has a huge capacity when it's opened to deal with newcomers. So we are prioritizing the opening of that center. We have a number of site visits to that center. We are very happy that it will become a best practice model for us on a refugee center, Chair. So we are eagerly awaiting the opening of that center, which will alleviate the pressure on the other centers. And then lastly, Chair, it's overtime because of the high volumes and the backlog that we have built up. We have put a submission together and we envisage to start working overtime from 1 October until the end of the financial year to really deal with the applications that we have on hand. On that note, Chair, I want to, the presentation is then submitted to the Portfolio Committee, and it's recommended that the Portfolio Committee note the presentation on the reopening of the refugee centers. Thank you very much, Chair.
Thank you, Mr. Simons. Minister?
Yeah, Chairperson, just before calling the next speaker, I want to report to the committee that the progress that is being made on the Cape Town Refugee Reception Center is actually overseen and monitored by a judge, because you may remember that this was a problem between us and Public Works, but the matter went to court. So as to whether we're making progress and we are living in terms of the cost order, the judge frequently visits this center, and as far as I'm concerned, is satisfied. I want to emphasize that we work within the laws of the country. We don't do anything out of our heart, we follow the laws. And that's why the opening of the reception center is actually monitored by a judge who records his satisfaction of whether we are doing the right thing or not. The second issue is on statelessness, Chairperson. I'll call over the DDG for Civics, Mr. Sigama, to do the issue on statelessness. And I must advise upfront that when people talk about statelessness, they think about somebody from another country. I want to explain, because it might not be clear to you when the definition comes from United Nations. According to the United Nations definition, people can be stateless even without having crossed any border whatsoever, simply by not having documentation and living in a particular country, having never left that country since they were born, being bona fide citizens of that country, but they may be rendered stateless because of having no documentation. And we meet such people every year in our country. On these trips that we are making around the country with mobile units, we do find 60-year-olds who have never had any document in their life. In a way, those will be people who are also regarded as stateless until such time that they are given their documents. So I'll call over Minister Sigama. I think this is the shortest of them all. Thank you.
Is the minister of what?
Mr. Sigama is a DDG for Civics.
Oh.
Chair.
Minister Sigama.
I said Mr. DDG
Thank you.
Sigama, Mr.
Thank you, Minister. Mr. Sigama, DDG.
Thanks very much, Chairperson, and thanks very much, Minister. Members of the committee, mine indeed will be a very short presentation. I'll be taking the portfolio committee on statelessness. As Minister indicated to earlier, I think we'll have to define what statelessness is all about. It is, or a stateless person is defined under the international law as a person who is not considered as a national by any state under the operations of its law. Although stateless people are also reduced, most stateless persons have never crossed the borders, as Minister indicated earlier. The concept of statelessness is misunderstood, and there is misconceptions, and it's often misinterpreted. Then you will recall that on the 8th of December, there was a march to the Home Affairs by the Consortium of Refugees and Migrants in South Africa, COMSA, to demand South African birth certificate registration for children of refugees and asylum seekers. It is against this background that the Minister of Home Affairs engaged the UNHCR Assistant High Commissioner for Protection, Ms. Gillian Trix, at a high-level bilateral meeting that was held on the 25th of January 2022. So in that meeting, Chair, if we can move to the next slide. In that meeting, Chair, stay slide 5, the UNHCR agreed that South Africa is not obliged to grant citizenship to every child born in South African territory to non-South African parents, unless there is indication that it would lead to statelessness. And in line with the 1961 Convention on the Reduction of Statelessness, kindly note that South Africa is not a signatory to the 1961 Convention. So the meeting, if we can proceed to the next slide, the meeting between the Minister and the Assistant High Commissioner of UNHCR also agreed that the practice of South Africa of issuing a record of birth to children born on South African soil, but of non-South African parents is the correct one. And the record of birth should be presented to the embassy of the parents' countries of origin, who they issue the birth certificate in accordance with their laws. I'm sure you've heard Minister trying to expand on this matter, to say when a child is born in South Africa, we always provide a record of birth so that those parents can then visit the nearest embassy to then get the birth certificate of their children. So the UNHCR, if we can go back to slide 6, Chairperson, see the presentation is now stopped.
Yeah, it's not moving, Mr. Skama.
Slide 6, please.
Thank you.
Yes. Thank you. The UNHCR and Government of South Africa agreed that a common statement on the definition of stateless person will be issued, but at that point, we have not yet issued that statement, but there were common grounds during those deliberations. So it is important to note that indeed, whatever South Africa is doing is something that has been recognized, and it's something that indeed we will live to it and make sure that those that are born in the country, they're provided with record of birth so that they can then visit their nearest embassy for them to get the proper birth certificate in accordance with the laws of their countries. So then the slide 7 then talks to the parental linkages, which then talks to Section 5 of our Birth and Death Act. Chairperson, I must indicate that this section indeed makes provision to those who want to register to say, in the case of a South African citizen, particulars obtained from the birth notification shall be included in the population register, and such inclusion is the registration of the birth consent. This is how we normally register birth. We look into the Act, we look into our regulation, our SOPs, and make sure that we then talk to Section 5 so that we then register children that are in need of our enabling documents. Then the next slide talks to the acquisition of citizenship, which then makes reference to Section 2 and subsection 2 of the Citizenship Act, Act number 88 of 1995, which clearly states that any person born in this republic and who is not a South African citizen shall be a South African citizen by birth. If, that's number 1, he or she does not have citizenship or nationality of any country, or has no right to such citizenship or nationality. And second one, which is B, says if his or her birth is registered in the Republic in accordance with the Birth and Death Act, which is Act number 51 of 1992. But also it is worth noting to say a South African birth certificate has a South African ID number, and therefore this means that it can only be given to South Africans. I think it is important when we deal with this aspect so that they understand the rationale between the record of birth and how we then make a distinction to those who have to acquire a citizenship and what are the conditions wherein all these people will have to get to gain access to our South African documentation. Then lastly, is to indicate that we would like to really recommend to the Portfolio Committee on Home Affairs that the presentation of statelessness is shared for information purposes. Thank you, Chairperson.
Thank you, Mr. Skama. Minister?
Yeah, Chairperson, the last presentation is on the issue of the backlog project. I've already outlined what actually the backlog means, and I want to emphasize again, it's a backlog of people who come to South Africa looking for asylum or refugee status, who have been processed and were not successful, but then they enter the appeal process. And that appeal process has got lots and lots of backlogs because it's over elaborate, and as I said, it's unending. And it's a joint project between us and the United Nations to clear this backlog, which started building from 2008. It's not a backlog that originally started with Home Affairs. It started on 2008 when the economy of many countries collapsed, especially more so in Zimbabwe, and lots of people ran to South Africa, most of them, of course, being economic migrants, but coming under the asylum and refugee system. And that's how the Backlog was built. Now, the Backlog project is under the auspices of RASA, Refugee Appeals Authority of South Africa. RASA chairperson is a statutory body under a law passed by a parliament that we must have a refugee authority to which people can appeal. The other body, which is not presenting today, is SCRA, or Standing Committee on Refugee Affairs. That one is not the Standing Committee of Parliament. It's also a statutory body under the Immigration Act, established by an Act of Parliament, where some of the appeals will go, as it will explain to you. The person to make the presentation is a new chairperson of RASA. You have never met her before. The previous chairperson, we have got a new one. She's Advocate Zelfara Pesu. I think I will ask her to show her face before presenting. Maybe thereafter she can, close a video. She can mute a video, but you are meeting her for the first time. That I'm introducing her. RASA has got a new chairperson, and she's going to make the presentation to you. Thank you very much.
Thank you, Minister. Advocate. You are muted, Advocate.
My apologies. Good morning, Chairperson. Good morning, Minister, and good morning to all the members. My name is Zelfara Pesu. I'm the new person at RASA. I joined RASA this year in June.
Can you show your face, Advocate, just once, please? Sorry, Chairperson.
Yes,
Minister,
yes, Minister, my face is on.
Minister is the one that is disrupting.
Are you all able to see me?
Yes, you can proceed, Advocate. Yes, you can
Minister,
proceed.
can you see me?
No, can see you.
Okay.
The chairperson can see you.
Oh, thank you.
Proceed.
Oh, thank you. May I then switch off the video now that you have seen me to start with the presentation?
No, thanks, Advocate. Thank you for it.
Thank you. I'll start my presentation by the introduction, which is the background. I'll elaborate what RASA is, as the Minister has already summarized, and proceed right along. RASA is an independent statutory body established in terms of the Refugee Act. Our primary mandate as RASA is to consider all the appeals made against the decision of the RSDO. The RSDO, the State Refugee Status Determination Officer, as the Minister has already indicated, that RASA's mandate is to deal with these appeals which are emanating from failed asylum seekers. Now I will outline the process for a better understanding of the members, how it works. When an asylum seeker arrives on the shores of South Africa, they arrive at an RRO, Refugee Reception Office, whereby they will make an application and they will be heard by an RSDO. And an RSDO can either grant the asylum seeker asylum or reject the application as manifestly unfounded, abusive, or fraudulent, or as unfounded. I'll elaborate on the two. Applications which are found to be manifestly unfounded are dealt by the Standing Committee on Refugee Affairs, and those that are found to be unfounded, they are dealt with by us, by RASA. So let me elaborate on what we mean when we say a claim is abusive or manifestly unfounded. And manifestly unfounded decision means that...
Sorry, Advocate. Advocate, I'm not sure is it on your side. There's Bra Eddie, there's somebody's not muted. I think the person disrupting the presenter. Okay, proceed. Thank you.
Thank you. As I was saying, I was elaborating on what we mean when we say a claim is manifestly unfounded and when we say it's unfounded. When we say a claim is manifestly unfounded, we simply means that the application for asylum was not made on the grounds other than those contemplated in Section 3 of the Act. Section 3 outlines what a person who qualifies for a refugee is. And Section 3 provides that owing to a well-founded fear of being persecuted by reason of an asylum seeker's race, gender, tribe, religion, or nationality, they may qualify to apply for asylum under subsection 3A, and subsection 3B provides that owing to an external aggression, occupation, foreign determination, or other events seriously disturbing public peace, one can qualify for refugee status. And the last subsection will be C, which categorizes a spouse or a dependent of a person already being contemplated in A and B as a refugee. So those that don't fall under these categories, they will be held to be manifestly unfounded. And those who are unfounded coming to RASA, yes, their claims fall under this subsection A, B, and C, but there's an issue maybe of credibility and other issues whereby an RSDO does not see it fit to grant asylum. Therefore, they then proceed to appeal through RASA. So that is the background of what RASA does and what we are all about. And I'll move to the next slide. I'll summarize. It's slide number 4. As Minister has already indicated, we've seen as South Africa a highest peak of influx of asylum seekers around about 2008 due to the economic meltdown which many countries experienced. South Africa also experienced a recession, but in our region, Zimbabwe was the hardest hit and with a near collapsed economy. So from this period going forward, we saw an avalanche of asylum seekers coming through to our shores. And for the first time, South Africa received an asylum seeker in such numbers that the system could not keep up with the demand. Similarly, RASA also was subjected to these unprecedented numbers of failed asylum seekers. I would like to put across that then in 2008, the Refugee Act for RASA to be constituted by a chairperson and 2 members, 2 or more members, 2 or 3 members who will deal with the appeals. So it became a problem in that as they were sitting as a quorum, the requirement was that they must sit as a quorum at any particular time while hearing this and determining these appeals. So the problem came where we receive a large number of failed asylum seekers who have been rejected in the first instance by the RSDO. So the Refugee Appeal Board, as it then was, then devised a means to say, because of a large number of asylum seekers, we will then adjudicate these appeals and determine them as sitting as single members. Because as we're sitting as a quorum, it creates a backlog for RASA. Remember, we've got 5 refugee centers in the Republic, meaning they will move from head office in Pretoria to go to Gqeberha and then proceed to Durban, proceed to Cape Town, proceed to Messina to have this these hearings as a quorum. So that as well contributed to what RASA has now, a backlog. I'll proceed to the next slide. And I must also mention that during that period, there was a decision of the Western Cape High Court by the name of Hereri Mana versus the chairperson of the Refugee Appeal Board, where we were taken to court merely because we were not constituted as a quorum. That decision that RASA had initially taken to sit as single members to adjudicate on this application in order to clear the backlog came back to bite our hand, whereby the court found that the processes of hearing was procedurally flawed in terms of Rule 53 of the rules of the High Court, and we were ordered to remit the matters back to the RAB. Then some decisions were substituted by the judges on the bench to say grant these people status. So having this jurisprudence at hand, the department then sought to amend its legislation so that a single member that can then proceed to hear one appeal, and the act was subsequently amended. So I'll briefly also touch on what the minister has highlighted on the inflow of economic migrants. The situation that we have now in South Africa is that there is no legislation currently dealing with economic migrants. Yes, we've got genuine and bona fide asylum seekers, and yes, we have what we call economic migrants, because as we're adjudicating their claims, some of them during these hearings, they are in their claims, they will say that they are here to make a better life for themselves. They are here for greener pastures. They are here to seek employment. So in essence, those are our economic migrants, as they say that they say that themselves without us insinuating. So we currently don't have a legislation that deals with economic migrants. Similarly, our international treaties, conventions, and protocols, either they do not provide such a legislative framework for us to deal with economic migrants. And as a result of that, everyone who's a failed asylum seeker in South Africa goes through the processes of appeal. So it is what we can call an unending bureaucratic ladder, because everyone who's here, everyone who's here who's an economic migrant, if we are rejected on the first leg, and then you'll proceed to the second leg, to the third leg, up until to the last leg. So this is an unending bureaucratic ladder of appeals that we have, unfortunately, and that is contributing to what we have now as a backlog, because we have to determine each and every claim as it comes to us, whether there's merit into it or whether there's no merit into it. We have to adjudicate, listen to the asylum seeker, and write a decision to that effect. And it is just not a decision, it's a decision whereby RASA has to apply its mind, because if it doesn't, these decisions are reviewed by the high courts. So we don't want to find ourselves being said, go back and rehear this because you did not follow the processes. So RASA has to be careful and has to look at all applicable laws in order to come to a suitable conclusion in finalizing its appeals. I'll move to the next slide. In view of the rising number of these appeals, and with the background that I've already put across, then the department and the UNHCR joined forces in order to assist to eradicate this backlog appeal cases, and to prevent similar backlogs from recurring through the provision of capacity support to RASA. I'll mention again that the constitution of RASA, as per the Refugees Act, it constitutes a position of that of a chairperson and 2 or 3 members. And with this partnership with the UNHCR, we see RASA being capacitated. UNHCR, through this agreement, has pledged to provide RASA with 36 members to come and adjudicate on these appeals. These 36 members will be mainly legal professionals, because, as you know, we are a quasi-judicial authority. We are a tribunal acting as judges in these circumstances. Our determinations are judgments in the real sense of the court. So the DHA signed a project partnership agreement with the UNHCR on the 8th of March 2021. And this agreement has paved a way for the implementation of what we call Plan 2019. And I've indicated there the total cost of the plan with the employment of these 36 members, which is 146,784,364. So the department similarly has also pledged on their part how they were going to assist this project by offering administrative support and many other support structures to RASA. Then I'll move to the backlog project background. As I've already indicated, that the department was, RASA was lambasted in the decision of Herere Mana on single decision making by one member. We moved from that, and then the plan, through the plan and development of the project, we developed an adjudication strategy based on the assumption that certain conditions will obtain, such as amendment of the legislation to allow RASA members to consider appeals cases individually in terms of the Herere Mana case. So this plan 2019 between the department and the UNHCR stands as an ultimate roadmap to guide the implementation of the backlog and to conceptualize this adjudication strategy. The next slide. The next slide deals with the project, the scope of the project. Says there, the project sets various aspects of the project to come to an efficient, cost-effective, and fair decisions. And you will see there that there is an amount of 133,582 cases. This is our backlog. This is according to our National Immigration Information System, also known as NIS. This is what we have eradicated from the system as the current backlog that RASA has. So I would also like to submit that this backlog was closed on the October 2021, meaning this 133 as it stands, it's appeal cases up until October 2021, when we closed the project to then determine that this is our backlog. So these cases are also divided into three main categories. We have heritage files, which are appeals emanating from 2011 and prior. And then we have our mid-range files between 2012 and 2016. And then we have current files, which will be files from 2017 and that October 2021 when we closed the backlog. So the next slide, it will show the backlog statistics. You will see that we have all our refugee regions on the slide: Cape Town, Durban, Musina, Tabera, and Desmond Tutu. So nationally, this is what constitutes the 133,000, the highest being appeals in Desmond Tutu, which is in Pretoria and covers the entire of Pretoria and Johannesburg. They are sitting at 66,264, with the lowest of appeals being in Tabera, which is 2,878. So on the far left, we see those categories: heritage, mid-range files, as well as current files. So there as well, we will see that the heritage files, they are the highest. They are 66,303, and then followed by the mid-range, and then the current files. I'll move to the next slide. The next slide, in essence, it details and tell us who do we have in the backlog, in the appeal backlog of the RASA, and according to their categories in terms of the age. You can see there that we have our infants 0 to 4 years. We have a total of 173 sitting in the backlog, meaning these are dependents to their parents. And then the second one, we've got a group of our teenagers, 5 to 17 years, which amounts to 5,626. And then the next group will be the working class. I'll say the working class because it's 18 years to 59 years, which is the majority of our appellants. They are 127,077. And then the last batch will be our oldest, 60 years and so forth, which are 706. It is not a big amount. So the big amount on this line, it will be our working class, 18 to 59 years old. This takes us back to the issue of having also economic migrants on our system, looking the backlog even further. This is the class where we find people who are still employed. I'll move to the next slide. The next slide deals with the training of members. As I've already indicated, that the department, as well as the United Nations, have partnered so that we can capacitate RASA to have members to assist. These are the members. The members have undergone training in various aspects of the refugee law, in particular on topics pertinent to the role that they will be playing, that is determining refugee appeals. Underneath there is the topics we covered, which includes status determination, establishment of the facts and credibility, country of origin information, administrative and constitutional law, judicial reviews, immigration and detention of illegal foreigners, as well as sexual orientation and gender identification, and most importantly, the interviewing skills and the appeals procedure in terms of the laws. RASA and the UNHCR collaborated on identifying suitable topics to ensure that all these new members are appropriately equipped to adjudicate and finalize on these cases in accordance with the best practices. More training of members has already started. It started yesterday, and it is offered by the Judicial Institute of Africa, JIFA, relating to the administrative and constitutional law, as well as decision writing and judicial reviews. RASA has also extended an invite to the South African Judicial Education Institute, which is SAJ, through the Office of the Judge President of the Gauteng Division of the High Courts, who also sits as a president of the International Association of Refugee and Migration Judges, to offer training to our members, and our request has since been received with warm hands. Before I proceed, let me also briefly tap on this. We have attracted qualified lawyers. When I say qualified lawyers, I mean admitted attorneys and admitted advocates. So we must also be mindful that refugee laws and immigration law are specialized fields. And them being specialized fields, we couldn't attract many people who are familiar with this legislation or rather regime. So these members had to undergo thorough proper training because they'll be dealing with a life of individuals who are here to seek asylum and refugee, and we don't want a situation whereby somebody was not granted asylum when they deserve because they could not grasp the content of the act itself. So the training is ongoing. The training is very, very intense. And from our side, we see there's an improvement. Members are starting to properly and deeply grasp the content of the act, of the Refugees Act. The next slides talks about the recruitment and the appointment of members. Yes, as I already indicated, the first group of the project came into board in June 2021, and then the next group joined in July, whilst the last group came on board in August, to bring a total of 31 members of the envisaged 36 in terms of the agreement. And out of the 31 members that we have recruited initially, 5 members have since resigned between the period of January and August 2022. And as things stand, we are currently having 26 members, and recruitment of the outstanding 10 members is underway in the coming few weeks. And then that will increase our capacity from 26 to 36 members. And if I must say, the reason why the 5 members left, some they went back to their law firms as they came on board during COVID, and now things are looking bright, and then they went back to their practices. And then 2, they left to pursue other career interests. And 1 was Professor Bani Pitiani, who was my deputy. He has since left to join the Lotteries Board. I'll move to the next slide. The next slide, I'll just pass because it deals also with the capacitation at RASA. This means the admin staff that we acquired. Now that we've got a large contingency of members and we are on a project, the department has also pledged to do their part. We have offered an office manager position, which never existed before. And the office manager started in January this year, as well as appeal clerks who started in December and January this year. We have further received 9 graduates from the department who are graduate learners to assist members with their day-to-day dealings when adjudicating these appeals. And we have now also received 12 interns from SACITA, the majority of which are LLB graduate, and they are based in all regions. So it means that every region will receive 2 interns. The interns will assist the members with their day-to-day administrative work to fast-track this hearing of appeal process. The communication outreach, these are strategies that we are currently developing in order to reach our asylum seekers wherever they are, because as a country, we do not have a system to track asylum seekers. South Africa, as well as being the only country with integrated asylum seekers in their communities, I'll call it an oversight maybe on the part of our government to say we did not put processes in place to track these people, these asylum seekers, as in when they get integrated into our society, since we don't have an encampment system. So the result is, as RASA, for us to hear an appeal, we need to issue a notice which is desired to inform an asylum seeker who is an appellant before us, to say, on this day, you are before us, going to hear your appeal, and in order for them as well to prepare themselves to bring legal representation and an interpreter when it is necessary. So that period requires a 30-day notice for them to come over. So with this communication outreach, it helps us because some of them, we cannot locate them. You can understand a situation whereby somebody has since entered the Republic in 2012. So you don't know their whereabouts now, and maybe they've also changed their SIM card 3 times already, or they don't even go to that email address that they have provided us. So we are improvising, we are providing the means to get hold of them. We do also reach their stakeholders. We developed a brochure and a pamphlet, which we are currently distributing to asylum seekers regional offices, NGOs, and other stakeholders. And a stakeholder engagement was held in February 2022 to introduce this project and to inform the refugee community of the expected role and need for cooperation for smooth running of the project. As I've already indicated, that we have those constraints that we are struggling and to proceed with making determination if we don't have an appellant before us. So these are some of the means that we've employed to reach to the applicants. We've got a system underway, which will be an automated WhatsApp system. We have a system whereby these asylum seekers are blocked when they are renewing their Section 22 to say, before we can renew for you, go via RASA so that you can acknowledge receipt of your hearing and then come back to us to extend. And that has been working tremendously for us as RASA. And then the next slide is our adjudication strategy on how we're going to deal with this backlog going forward. Our adjudication strategy includes tools such as file streaming and strategic member assignment. This approach includes the streaming of cases into categories that I've already indicated earlier, so that we maintain both efficiency and quality decision-making. The adjudication strategy divides the backlog of files into 3 categories, as I've mentioned: the heritage files, the mid-range, and the current appeals. It is also within our mandate as RASA to make a paper determination as an adjudication strategy. Paper determination, I'll explain it to say, is where we don't hear an appellant at RASA, but we would have informed a particular appellant that we've got everything that we need before us. We are proceeding with making a decision. And then if an appellant insists or would like to be heard by RASA, then we invite them to come. But if we agree that we have everything that we need before us, including their representations that they made through an affidavit, then RASA can then proceed and make that paper determination without hearing the appellant. The next slide taps on the backlog project progress to date. And I'll state that as of 2021, RASA began allocating files to members for streaming, and a recommendation of appropriate adjudication approach towards the finalization of these cases. And it must be noted further that the hearings only commenced in 6 December 2021, as RASA and as the department and the UNHCR were still finalizing some aspects of the agreement. So this stats, as it stands now, emanates from December 2021. And at this stage, yeah, we have statistical reports, which includes weekly dashboards to track productivity, which is shared amongst ourselves and the UNHCR on a weekly basis. And we have also developed a case management system in order to swiftly eradicate the backlog that we have. The next slide is it's a backlog project statistics to date. It is slide number 20. This describes the cases that we have requested from the centers to date, the ones that we have scanned through our online system, and the cases that were allocated for review. Review is a step that the adjudicator, a member, does before the hearing, where you can review a case to say, okay, this is a case from DRC, this is how I'm going to deal with it going forward. Hearing scheduled, there's a number there. And then on the hearing scheduled, maybe members will ask why the hearing scheduled does not correspond with the number of decisions that we have to date. I'll go back and tap on the issue of the communication outreach, that as RASA, we are still on the phase where we were struggling to get reach of these asylum seekers, and we are relying on their community representatives and many other avenues that we have employed to get to reach to them. So we are now, since I'll say June, seeing an improvement whereby we are able to reach to the asylum seekers through these mediums that we have employed. So the reason the stats here doesn't correspond is that at that stage, we were struggling to locate asylum seekers, and also be mindful that having been a struggle for us, we cannot proceed and make a decision, because tomorrow, if they take us to court for a judicial review, we won't have a defense, because indeed we did not hear them, we did not notify them of the hearing, and as a result, it creates a further backlog for RASA. The next statistics is the same as the previous one. It's just elaborative enough here. Is the stats to date, September 2022. So the next slide, I'll go to the interventions that RASA has to reduce this backlog. As I've indicated, our primary mandate is to finalize these appeals. And this is also in keeping with the Department of Home Affairs mandate to manage international migration efficiently and securely. So what RASA has as a plan is that new legislation, which was promulgated, which allows us a single member hearings. So this has already been done. The Refugee Act, as it stands now, it has been amended, and it enables RASA to adjudicate as a single member, which is the cornerstone of our agreement with the UNHCR to see the appeals moving forward. And then another plan that we want to look at and employ as RASA is to make group decisions. So in terms of this point, our rules at RASA, they permit RASA to also look at adjudicating for asylum seekers in groups where a similar question of law or fact arises, or where an asylum seekers are members of the same family, where it is practical and efficient for RASA to proceed with more than one appeal. When it comes to the adjudication of new appeals, as I've indicated, we have closed the backlog until October 2021. One will ask what then happens to the appeals that are lodged post October 2021. So this is what RASA has in its plans. Some of the members will be assigned to deal with the new incoming appeals to avoid recurring backlogs once the project is being finalized from recurring. So we don't want to be sitting with another backlog whilst we're trying to clear this backlog. So some of our members will be assigned to deal with the new appeals as they come from the refugee status determination officers. And also the issue of technology, RASA has moved to digitalization of files. It is common cause that the department the departmental files are manual files. So we are all moving to the direction of digitalization. So to date, I'll say RASA has digitalized about 11,818 appeals, which are already on the system, which the members can be allocated to deriving them from the system. And since the project has started, this has, as we can say, it and highlight for us at we see progress in terms of getting complete files. I must emphasize that there is no court of law or there is no tribunal which can adequately hear an appeal without an incomplete file. Because at the end of the day, you have to make a decision, and what kind of a decision will a decision maker make without a complete file? So that is one of the hurdles that we had to overcome, and I'm happy to submit that we have since passed that hurdle. We are digitalizing the files and we've got complete files, and yes, we are moving right along and should see greater results in the next coming few weeks. And lastly, another intervention will be a live online system which is underway. It was presented to RASA by the department, which will be able to track productivity of the adjudication process, automatically update statistics, and monitor overall performance across all regions. This, I mean, performance of all our 36 members, so that they are accountable to say if one is allocated 5 matters today, it will show on the live system. And when it's time to hand in the decisions, it will also show that these decisions are due, so that we work on the same footing, and then they are accountable to enhance the performance of the members. The last slide is the recommendation. I will submit that the portfolio committee note the presentation of RASA on the backlog project. Thank you.
Thank you very much for detailed presentations. Minister, I think these are the last three, is the last presentation of the three.
Yes, Chair.
Okay. Can we then take the last presentation? Mr. Matonzi?
Chairperson, Eddie has left us due to load shedding. Can I just confirm if the next presenters are presenting for themselves, or if they want me to flight their presentation?
Are they co-hosts? Did you make them co-hosts, Mr. Adam?
I believe Eddie made them co-hosts, yes.
Okay.
Yes, I believe that should be fine from our side.
Okay, no, thank you. You can proceed.
Mr. Igor Chovanu, I think you have been invited to take the floor first, yes.
Yeah. First of all, thank you very much, Honorable Chairperson and Honorable. Yes.
So can you share the presentation, Adams? Mr.
Yeah,
Salmo?
please. Yes, can you project the presentation?
Yes, I'm doing it while you speak, yes.
Okay.
Okay, thank you.
And just move to page 2.
Honorable Chairperson, participant, is it visible now, the presentation?
Yes, it is visible. And Honorable Chairperson, thank you very much for this opportunity to be present here and with you for the portfolio committee. Also, take note of the presence of Honorable Minister of Home Affairs and Dr. Motsoaledi and his colleagues. Also, I would like to thank the Secretariat, Eddie Matonsi and Adam Salmon for facilitating our presence here. And also, I would like to thank all honorable members of Portfolio Committee. Mr. Chairperson, our presentation will focus on 3 main points. And these points will be related to backlog project, to reopening of offices, and statelessness. In this regard, I would like to again mention, as Honorable Minister Motsoaledi mentioned already, the engagement of government of South Africa with United Nations High Commissioner for Refugees in high-level dialogue. This year in January, it was a unique opportunity for us to renew the engagement of the government and UNHCR on the main strategic areas of collaboration, and specifically we are working together under a plan of 5 years to improve or to review some aspects in terms of legislative reform, in terms of amending Refugee Act, judicial engagement, statelessness, refugee status determination, including backlog project, durable solution, and statelessness. I would like to mention, because when honorable member of committee, portfolio committee, Madam, yes?
Sorry, the presentation is not moving. I'm not sure whether you've
Yes,
started.
can you move to second file, please?
So that those that don't have the presentation, they benefit from
Yes.
your input.
Yes.
Thank you.
So I just will do this introductory part, and my colleague Jesus Perez Sanchez will take further to present all these 3 points, which you can see now on slide 2. But I wanted to mention that Madame van der Merwe, she mentioned a very good practice which South Africa is implementing, and specifically she mentioned about opportunities for integration for refugees and not building camps. I think in this area, not only in this area, South Africa is playing a role by influencing other countries in neighborhood, and not only by good practices. So I will stop here, Chairperson, and will give the floor to Mr. Jesus Perez Sanchez for presenting further our presentation. Thank you.
Okay, thanks a lot, Mr. Chobano. Through you, Chairperson. Good morning again to honorable members of Parliament, honorable Chairperson. So just going forward into the specific 3 items that were requested to present. Asylum appeal backlog project is one of them. You may hear that a lot of the points that I'm making have also been addressed by the relevant colleagues from Home Affairs. But just to flag once again that it's one part of UNHCR mandate that has been reflected also in the global compact on refugees, that as honorable members of Parliament know is one of the key international commitment at the global level towards refugee protection. UNHCR invests heavily on systematic support and supporting governments around the world to create asylum systems that are fair, efficient, adaptable, and with integrity. So with that mandate in mind, we embarked in the support of the current support to the Republic of South Africa to address the backlog of asylum appeals. That started in 2019 through developing an independent expert that assessed the situation of the appeal states, as the minister mentioned before, and put forward a proposed plan, a vision plan, 2019 plan that's sort of the inspiration of the current asylum appeal backlog project. In March 2020, the 4-year project partnership that RASA also made reference to kicked off with 2 distinct goals. One is to eliminate the existing backlog of appeals, and secondly, to introduce mechanisms to prevent new backlogs from forming. And there is a number of elements that are critical objectives of that project. One is digitization to efficient decision making. Also, importantly, the roles of key support staff that will conduct research on countries of origin, prepare files, and stream the cases that will facilitate the final adjudication by the eligibility officers. The agreed plan also put forward proposals that some individuals that we are now rating, quantifying around 55,000 in the backlog. These are those who applied before December 2011, receive consideration for alternative immigration measures based on agreed criteria, not related necessarily to refugee status, but rather taking into account their long presence in South Africa. This is what we call the heritage files that were also alluded by RASA. UNHCR continues being an active member of the Backlog project. We have an advisory group that is the key governance group in the Backlog project. It's formed by Home Affairs, the RASA, and UNHCR, and continues offering financial, staffing cost of the appeal adjudicators, and technical support to the project through expertise. Technical expertise on country of information, trainings that the RASA member also alluded to. So in terms of successes and challenges thus far in what is the second year of implementation, successes as Advocate Rafesu mentioned, we now have the great majority of appeal officers in post and based around the different offices throughout the country. A new chairperson who took the floor today, Ms. Rafesu, was appointed and is taking charge of the project. The engagement with between UNHCR and Home Affairs and RASA is open, positive, and collaborative. As regards the heritage cases that I mentioned, there's been a heritage file committee created. And importantly, I made reference before to the Global Compact for Refugees as a very strong anchor of international advocacy, global advocacy towards refugee protection. Well, South Africa pledged the commitment to address the backlog at the Global Refugee Forum, and is now in contact with other countries through this Global Asylum Capacity Support Group mechanisms, which we commend. Respectively, there are some challenges that we see still there, and that we work constructively with the different members of the advisory group to address. The number of appeals remains still low. There was 450 decisions made and 284 incomplete files returned back to Home Affairs. I noticed the more updated figures that Minister Rafesu provided today. The quality of interpretation is something that has been flagged as an area to improve. Some files that are incomplete and must be sent back. The full complement and the full engagement of appeal members and vital support staff. So we noted, we were glad to hear from Advocate Rafesu on the upcoming engagement onboarding of their remaining eligibility officers to adjudicate. There has been some delays with the project manager that we now see progress being made towards. And the refugee appeals officer, we noted the update from Advocate Rafesu on different interns, other support staff that are fulfilling that role gradually. Heritage files are still being verified, so it's something that the Heritage File Committee would be sized with. And obviously there will be a great impact on lowering the numbers, the backlog numbers that we heard before from Home Affairs members, the 132,000 that was alluded to before. Obviously, by addressing the heritage files, we may see a considerable reduction to those. In terms of way forward, we continue supporting Home Affairs and RASA to ensure that all features of the original plan are implemented as agreed, including not only the staffing support, but also ICT equipment. There is a full support by a project manager, implementation as per the new adjudication methodology that also Advocate Rafesu made reference to. And indeed, and we appreciated the reference to this from Minister and other distinguished members from Home Affairs. The high-level dialogue continues being for us a key reference, a key commitment towards the collaboration of UNHCR and DHA. Obviously, Backlog project featured prominently, but also we explore the possibility of expanding support to quality of first instance asylum procedures, as other distinguished members also made reference during their presentations. Now, as regards the reopening of the RROs, we quite appreciated the updates provided by Minister DDG on the current numbers and the current work being done as after the reopening of the refugee reception offices throughout the country, after the end of the relevant national state of disaster and COVID-related measures. In particular, we were keen and supported the streamlining of services of applications online. We are also encouraged to hear of the very upcoming reopening of Cape Town RRO. There were some gaps that we've been flagging and observing. For instance, new asylum applicants, they will not be issued a Section 2020 asylum seeker visa until they lodge a notice of appeal against a first instance rejection. But we also took due note of the current efforts to address this matter from DHA. We also observe some very high first instance rejection of particular country cases that we will continue engaging on. And there was also the measure of refugees and asylum seekers with pre-COVID expired visas being referred to the National Prosecuting Authority. We understand those proceedings. We will like to suggest eventually some amnesty period, as it was suggested, and it was implemented before the COVID-related restrictions. But that's something that we'd like to continue engaging with Home Affairs, and we quite appreciated the plan presented by the DDG today to increase the capacity and gradually get into a recovery of full services at the level of prior to COVID pandemic. On the statelessness matters, hopefully, yes, the slide is coming up. We appreciated the definition provided by the minister himself, also by Mr. Sigama. Indeed, that's the stateless definition as provided by UNHCR. Basically, persons that are not considered nationals by the operation of any national legislative framework. We commend the statelessness related pledges that South Africa has made in the past. We noted the commitment to eventually accede to the UN Statelessness Conventions, 1954, 1961, that will further complement what is a very good level of accession to international commitments by the government. And even if that pledge has not yet been implemented, we see and we commend the progress towards statelessness-related matters by South Africa. So some of those positive steps that we've been collaborating actively with government has been progressing nationality legislation that grants nationality to children born and registered in its territory who will otherwise be stateless. And we also made reference to that as one of the key outcomes of our high-level dialogue in January this year. Also last year, the drafting of the draft ministerial declaration or regional action plan to end the statelessness with SADC, with the Southern Africa Development Community. The ongoing collaboration that we have as UNHCR with a government focal point on statelessness. Also the drafting of the African Union Protocol on the right to nationality and the eradication of statelessness in Africa. And very importantly, we're keen to have collaborated quite closely towards a national dialogue on statelessness that we co-chaired and that culminated on a national action plan to end and prevent the statelessness. We are just awaiting the final endorsement by key principals, but that set up a very progressive way forward on statelessness that cover matters such as identifying the key trends and dimensions on statelessness matters in South Africa, important discussions on citizenship bill, and also support to civil registration eventually in South Africa and border areas. So all those elements that were included in the National Action Plan is something that we will continue collaborating with the government and and relevant civil society actors. So with that in mind, we would absolutely remain available for relevant queries and questions from the honorable members of Parliament, and we appreciate the opportunity of presenting today. So back to the chairperson, and thanks for the opportunity.
Thanks very much. I think we are now have received all the presentations that we members must interact with. And want to thank Minister and your team for presentations also. Members, this take us to comment on the report that has been, reports that has been presented for our attention. After that, we'll then invite the team that has presented to summarize the responses or issues that will be arising from members. Advocate, I see your hand. Is there any other matter you want to raise before I invite members?
Chairperson, it's Adam Salmon here. We still have the Lawyers for Human Rights presentation still. Can I just confirm if they're with us?
Were you in the meeting when we started, Mr. Salmon?
Yes, Chairperson.
What did you hear when we were opening the meeting?
Did they indicate that Lawyers for Human Rights would not be joining us? Sorry, I was working on the submissions.
So why are you asking us that you know that they're not joining us in the meeting?
Oh, I missed that, sorry, Chairperson.
No, I'm saying you are confirming that we reported to the meeting that they're not joining us because of the tide of the program. I'm not understanding why are you raising the point which you're confirming.
I missed that, sorry, Chairperson.
Okay, noted. Thanks, Mr. Salmon. I'm going to invite members in that sequence. Honorable Lizel, Honorable Lokwase, Honorable Mokhale, Honorable Rose, Honorable Ramolobeng, Honorable Molekwa, Honorable Pile, Honorable Tito, Honorable Mudisimta. We comment on all the report. I think members, those that presented, pay more attention to notes so that we're able to respond. In that order, thank you.
Thank you very much, Chairperson, and thank you very much to all the presenters. Mine will be comments and a few questions of clarity. Firstly, I would like to say that I don't have any questions to the UNHCR, but just to thank them for their continued support to our country and also to our department in terms of managing the affairs of asylum seekers and refugees. But then I want to go to the issue of RASA, and listening to that presentation, I actually feel very sorry for RASA, I must be honest, because we talk about a backlog, but really what they face is an untenable situation. This issue of manual files, files that are incomplete, the inability for them to trace asylum seekers or refugees once they've integrated into communities, and yet they have to reach those appellants. Otherwise, once they get to a court process, they'll be found wanting. So really for me, it continues to, even though we talk about progress in terms of these presentations, I remain concerned that the system is failing us. And also we speak about this endless appeals. In other words, a person is turned down, they're not a legitimate refugee or asylum seeker, but our legislation allows for continued appeals. And I want to know from the minister maybe whether the mooted change in legislation will actually deal with these loopholes. During the RASA presentation, we heard that, of course, that many of these appellants can't be traced. I wanted to ask what percentage of appellants can normally not be traced. We also heard that many of these asylum seekers or refugees are in fact economic migrants. And I also wanted to know what percentage of applications are normally, in fact, economic migrants. RASA on one slide, it speaks to the issue of they've now got 25 staff members, but they need 36. I wanted to know what timeframes are we looking at in terms of filling those vacancies. And lastly, when we speak about statelessness, recently there was a lot of discussion around economic migrants or people who cross into our country to either use our healthcare services. And I heard the presenter speak about notices of births that are given to migrants. And I wanted to know how many of those are issued each year. And finally, I also just wanted to say that, I've never really heard our minister making any comments that he was accused of earlier. I do believe that our minister is a minister that seeks to ensure that he executes his responsibilities to the best of his abilities. And also, so I wanted to say that the comments earlier about the minister, I think, was unfounded. Thank you, Chair.
Thank you, Honorable Lizelle, for your contributions. Honorable Khwase. Honorable Mohale. Honorable Mulegwa.
Thank you very much.
Okay. You can proceed.
Okay, thank you very much, Chairperson. And thanks for the presentation that have been presented today. Chairperson, we also like to acknowledge the progress registered so far and also appreciate the intervention made in dealing with the backlog. I hope that in the near future, the issue of the backlog will be the issue of the past. We would like to note and welcome all the presentation as presented. Thank you.
Thank you, Honorable Ramolobe. Honorable Ross.
Thank you, Chairperson, and thank you to all the presenters. Chairperson, yes, firstly, I'd like to also echo what Honorable Lizelle said about the UNHCR. I think their contribution really to South Africa has been immense, and we really appreciate that contribution. Chairperson, I think it's a concern that we have these matters that we cannot close because of updated contact numbers. And even in other countries, I know it's very, I used to travel quite a bit, and you have to give your address at all times. You have to update the authorities if you deviate from that travel plan. And I think it's something we need to consider, Chairperson, from a legislative point of view. I don't know if there are any international law impediments against that. But we cannot have a situation where we have such an onerous backlog and then persons are just not contactable by the authorities. And technically speaking, the application has been rejected and then they're in an appeal process. So I think that's something we really need to look at, Chairperson. Persons should be contactable wherever they are. We should know where they are. So for example, I think it's Costa Rica, where literally the government has, they can tell you exactly how many refugees and asylum seekers there are, right down to a very granular level, because they implement that kind of system. Chairperson, then in terms of the RRO in Cape Town, I think it's quite staggering that it still isn't open. I think it's been about 4 years. So I want to understand, what is the time frame now? How soon before it opens? And are any payments going to the service provider? So are there monthly payments that we're paying? And what are the extents of these payments? I think it's critical, if what Mr. Simons was saying is true, that it is going to make a significant difference, that we need to ensure that it opens as soon as possible. Then I would just like to get a confirmation. The minister said that there's no backlog on new applications. I'd just like to get a confirmation on that. And then also in terms of the refugee status determination officers, giving a first instance rejection of asylum applications instead of a Section 22 asylum seeker permit. And I just want to understand why that is happening. Then in a previous meeting, Chairperson, I'd called for the possibility of an e-verification system because, you have health services, social development, etc. That valid refugees and asylum seekers are entitled to. I just want to understand the process of how do these organizations certify the validity of these documents that they might present. Because I had a situation, Chair, where over a weekend I got phoned and somebody had been arrested and they were incarcerated, and a acquaintance brought their documents and they were made to wait until Monday for a Home Affairs official to come and verify the authenticity of that document. So I just want to understand how, what processes are in place for government departments to verify these documents, and is there consideration for e-verification, or does a Home Affairs official need to come in working hours and verify that document? Then in terms of the backlog, Chair, I think it seems like we're quite a way behind, and I just want to get an understanding, are we going to complete this project within 4 years? And if we're not going to complete it in 4 years, what are going to be the funding implications? How is it going to be funding? Where are we? I think, Chair, if we are told that we have a project and it's going to be finished in 4 years, we need to not only understand where we are, but how are we going to get to the end? Then, Chairperson, in terms of statelessness, I think it's it's becoming apparent that we're not going to meet the plan to end statelessness by 2024. But I think the concern from my side, Chair, is actually a statement that was made in 2015 to Parliament, and it was by the Deputy Minister of Home Affairs, Fatima Chauhan, who said that Home Affairs is going to make screening more difficult for late registrations of births, because we know that most of who are taking up late registration are failed asylum seekers. And we see, Chairperson, that in our schools, on our LURIT system, there are almost 500,000 South African learners that are listed as undocumented. And my question in this regard, Chairperson, and I've asked it in various different ways, but how is Home Affairs going to ensure that these children do not fall through the cracks? Because I think many of them, if we say that the late registration of birth process is onerous, and they get to a point where they're 18 years old and they go out into the world and they're undocumented, as they get older, the chances of them meeting the requirements of late registration of birth, and that gets less and less. So I just want to understand from the Minister, what is the plan of the department in terms of trying to make sure that South Africans that find themselves undocumented for various reasons do not fall through the cracks, Chairperson? And then finally, Chair, just a question in terms of regulations that the court has required to the Citizenship Act for the for potentially stateless children of undocumented migrants to be registered. And I just want to understand where we are with those regulations. Thank you, Chair.
Thank you very much, Honorable Ross. Honorable Tito, if you have joined the meeting. Honorable Pillay.
Thank you very much, Chair. Chair, there's a Huawei Nova 8 that is disturbing our meeting. I've noticed that it's been happening even while Honorable Rose was speaking, but I did not want to disturb it.
Okay, let me intervene. Mr. Salmon, can you ask to mute the Huawei Nova 8? Is it possible? Mr. Salmon? Is Adams in the meeting? Mr. Salmon? Huawei number 8.
Sorry, I missed that, Chairperson. Say again.
Yeah, I request you, Mr. Salmon, if you can mute Huawei Nova 8. I think it's not, we're trying to request him to mute, so it's possible to mute him. Thank you. You can proceed, Honorable Pillay. Sorry for that, Honorable Pillay.
Thank you very much, Chairperson. Chair, I think firstly, I want to just concur with you. And I just want to, I think for the last time, place on record that the content advisor needs to follow the chairperson when it comes to meetings, particularly because at the beginning of this meeting, I think that was just time that we've wasted having to deal with a matter that we've already resolved on at the beginning of this meeting. Chair, I want to also appreciate all of the progress reports And I think it's important for us to give credit where credit is due. And I'm going to start off with the one that was presented by the acting DDG in terms of the progress that was made for online extensions. Chair, if you look at it, there's a phenomenal number of almost 87,478 in a period of 7 months. And I think it must be applauded as a department that this shows us that we are heading in the right direction. And I want to implore that we also try to use some of the best practices and learn from this experience in terms of how we deal with other different service units within DHA. Just a few questions, Chair, in respect of the online system. I just want to know if the department has experienced any system challenges, or perhaps maybe have they experienced a time where the system has been down, and how have they dealt with it in terms of the extensions. I also want to find out if there's any methods that the department's using in particular around tracking and tracing that number of almost 24,000 where they need to finalize it, where some of them have been sent back to offices and others have been requested to email further information or documents. Then in terms of the RASA and the backlog, Chair, I think I have to raise concern that while we have a brilliant system and I appreciate that we are making progress, but it's important to note that there is slow progress in terms of finalizing. For example, there were 364 hearings, and I just wanted to find out how long it took for us to do that. But again, out of the 364, there were only 195 decisions. What is holding us back from having to give the rest of those decisions, particularly since there was such a small number of hearings that took place? And then how long do they envisage that the digitalization will take in terms of files? And if I had to look at it, I think they've scanned about 1,418 case files. And this is quite a small number. Is there any way that we could be able to speed that process so that it assists all of the officers when it comes to having to listen to these hearings? And then, Chair, lastly, in terms of the registration of births, and I think this is in relation to statelessness, I just want to know how can the UNHCR be able to assist or aid in respect of birth registration, seeing that High Commissioner's offices are actually not assisting the process. And it is actually the responsibility of that respective country to issue a birth certificate to a child that is born if the parents are from that country. So I think that's where our challenge lies, where they are not doing it. And I think if there's any way that they could be able to assist or have some kind of discussion with the High Commissioner's offices of the respective countries, I think that will assist the process. Thank you very much, Chair.
Thank you very much, Honorable Pillay, for your contributions. Honorable Mulisemza. Okay, I think those are the issues that were raised by members. We'll start with the Minister. You will assist us to invite the presenters to respond to some of the issues. Then you will then summarize, and we invite the last presenter to also summarize on the issues that members have raised. Will that process assist us to get to the issues that members have raised? Minister?
Yes, indeed, Chair, it will help. Maybe before I summarize some of the questions, because particularly the questions to be answered are mainly from me, 3 members, Ms. van der Merwe, Mr. Roos, and Honorable Roos and Honorable Philip. Maybe let me first.
No, Minister.
Yes.
Sorry, Minister. Mr. Salmon, the Highway Nova 8 will request you, with due respect, can you mute or excuse the meeting?
Done, Chair.
Thank you. Minister, can you, okay. Sorry, Minister, I see a hand, Jeff Beloy. I see a hand here, Jeff Beloy. Are you part of those that must respond?
Hello, can you hear me?
Yes.
Yeah, good morning, sir. Good morning, ladies and gentlemen in the meeting. My name is Jean-Paul. So my question is, I know South Africa.
No. Hold it there. Hold it there. We're dealing with now on the responses of the issues that were raised by members. The minister and his team, they will respond. That is now the opportunity to interact with the committee in the manner that we're sequencing the presentation, and the minister may need to raise. Minister, can you proceed?
Yes, Chair. I was saying I will come and summarize later at the end, but I'll allow my officials. There's a question from Honorable van der Merwe of whether we know how many birth records have been issued. I believe that information can be obtainable from the civics. I don't know whether they've got it at hand or they'll have to go to the records, but it's a question that can be answered from the records. Yes, I'll try Mr. Sigama to try it and tell us whether he can respond now or issue the answer later after checking the records. And then the issue of how many economic migrants, I'm sure it's going to be a very difficult one because nobody comes here and say I'm an economic migrant. This is quite unusual. Usually people quote asylum laws because they know very well that that is what is in the conventions, international conventions, and that is what is in the Refugee Act. So I'm not sure whether we'll have a definite number, because I think an issue of economic migration is an extrapolation. We are extrapolating that people are not qualifying because basically they are here for economic reasons, not for the reasons that are mentioned in the conventions or in the 1998 Act. But if Mr. Yusuf Simons have got a figure on that, I'm sure he can also help. Thank you, Chair.
Okay, just to addition to that, if all their presenters, you might have picked up issues that the minister could not cover, you quickly just close up that gap. So it's easy for a minister to summarize. Then we'll invite the last presenter to also make comments. In that order, Mr. Simon.
Thank you, Honorable Chair. Honorable Chair, I'm also here with the Chief Director of Asylum Seeker Management, Mr. Mandla Madumisa, who can just put in some of the specifics on the questions, particularly from Honorable Ruas and Honorable Pillay. But let me start off. Honorable Ruas contacted me also on this particular case of a person that was apprehended for not having the asylum documents with them. And the challenge with that incident, and the question that was raised by Honorable Roos is, doesn't other governments also collaborate with the Department of Home Affairs on the verification? The response is, Honorable Roos, the verification system is available for all government departments, similar with the banks. So the police, for some reason or the other, prefers to call out our officials instead of looking at the system and verifying documents. It's a matter that we took up with that police station, because particularly if it happens over the weekend, our officials need to go out there and verify documents. So that is a particular problem, but as I indicated, the solution is there. The verification system is there that we make available to the bank. So SAPS also can have access to that system. Can I then allow Chairperson, just Mr. Madumisa, respond to the other technical parts about the opening of the office, etc.?
No, thanks, Mr. Simon. You can proceed.
Thank you, Honorable Chair, members of the committee, and Minister of Home Affairs, Deputy Minister, and the DG. Maybe let me start on the percentage of economic migrants. I confirm and concur with Minister that we don't have that figure outright, but if you look at the asylum regime, the rejection rate is 95%, which we then argue that the people who have made applications are making applications other than related to the international protection, which then might extend to the understanding that there might be economic migrants or other forms of migration other than international protection. Then coming to Honorable Roth's questions, the issue of monthly payments. Currently, the renovations are done by the landlord. We will then be responsible for payments once we receive the site, and the envisaged date of taking over the site from the landlord is the 30th of this month. That means we will be in Cape Town next week, Friday, to take over the site, and therefore immediately after that, on the 1st of October, we will be responsible to pay rental in that site, and we complete our installations. The installations that are required are the SITA lines, the data points, the desks, and other things. Of course, our work started parallel to the renovations, so we are expected to be able to conclude in some of our own installations as Home Affairs, and we envisage that we will engage, our minister will engage other relevant stakeholders, including the judge, on the official opening of that office, and we'll be able to advise accordingly once those data confirmed. We earmarked or envisage that our installations should finish just before the festive season, and maybe we look at to avoid working on busy schedules of the festive season. We look at early next year in that area. And then asylum seekers who do not get the permit. I think, Chair, I must admit that I'm picking up this one for the first time, and it becomes difficult to respond to. Was that in terms of the process, once you apply for asylum and get a decision, you must be able to get a permit, and after that, you are allowed an opportunity to determine whether you want to appeal the decision if it's a negative decision. If it's a granted, you're supposed to get a refugee status right away. That paves the way for you to apply for an ID or travel document, depending on what you want. Then the system downtime, I think, is a question that came from Honorable Pillay. Of course, during the day, as you are busy on the system, we are scanning files for the backlogs and all that. We do at times, but it's not that prevalent. Ever since we've been using the SITA platform, things are moving faster, but at times you will get a downtime there and there. But in the main, our systems are more stable than on downtime. They get slow towards midday. That's in the main, that's what we experience. The slight challenges you will find, it's a remote town of Musina. We are now in the process of trying to have a backup in terms of a mobile truck to make sure that the stability is similar to the rest of the centers. And then how do we track if people came to the office, those that were invited to come to the office for any other reason? Currently, we only establish after the day has ended that the person who was advised to come to the office on a particular day has not been serviced, and we assume that they have not come, and we don't want to rely on assumption. We have therefore instructed our service provider on the system to develop what we will call onboarding a solution where each client that enters the gate will have to have his letter of invitation scanned So we'll introduce a barcode on those letters. Number two, we take, because we have the solutions that take the thumb will confirm your presence. So at any given time, the clients that are inside the building, in the next 3 weeks, we will know who is inside the building. As management, therefore, we'll be able to track by midday, afternoon, out of the people that have checked in the building, how many have yet to be assisted. In that way, as management, we're able to intervene and say, indeed, these are the people that confirm using their thumb, using their letter barcode, that they are inside the premises. They are either by this time assisted or not assisted. So we'll deploy that in the next 3 weeks. We are just waiting for the finalization of the development. Then the last question relates to the digitization of files. We rely on the demand or the request from RASA here, but also as the senders, we are assisting the project by making sure that clients that are asking for extensions in this area, in particular those that are asked to come to the office, we don't miss the opportunity to make sure that one, the file is ready for the hearing. Number two, it's scanned for RASA to receive it. So we are using those two solutions. Where RASA has requested files, we don't give them the physical file. We scan that requested file into the system to allow them to finalize the file irrespective of where they are in the Republic. And number two, as clients visit our office, the files that are ready, we scan them. So that population of 11,000 was the solution that we're utilizing in the files that we scan and then we take it through the quality assurance. The files that you see, the figures that you see of the files are the files that have already been quality assured. We confirm and we know that they are ready. However, the files that are scanned, that are being taken through the quality assurance processes, they go beyond 20,000. And those figures, I did not put them here because we have not yet verified those files as being ready for the finalization. Thanks, Chairperson.
Thank you very much, Mr. Sigama. DDG.
Thanks very much, Chairperson. Good afternoon, members of the committee, Minister, Deputy Minister, DG, and all the members present. I'll start with the questions that were raised by Honorable Ross, where he indicated we wanted to check whether the stringent measures that are put in place in order to deal with the difficult cases in terms of the late registration of birth. Yes, I can confirm, Honorable, that indeed we have put screening committees in all our offices. As you may recall, our regulation indicates that if you register birth within 30 days, there are no issues. We only have to verify and register. And then the part that requires screening committee are for those that are above 31 days, up to 1 year, and 1 year up to 14 years, and also the last one, which is now called the LRB, which is late registration of birth, in terms of those that are 15 years and above. So we've got two committees that have been formed at a provincial level. One deals with those that are above 30 days, but less than 1 year. And there's another one that deals with those that are above 1 year, a chairperson. So those ones indeed are being implemented on a daily basis, and we are monitoring them at back office. Then the second one was around the plan to address undocumented persons, particularly for those that are at schools. Yes, as you are aware, Honorable Rose, we have got about 110 mobile units that are being used to support that. And we also have more than 391 health facilities that are connected. And as you're aware, there was a plan that was presented before wherein we indicated that in the period of 5 years, we will have to make sure that we augment all the health facilities that we have. And in addition, we'll have to make sure that we add more. Priority 1 will deal with those that are registering a high number of births. Priority 2, it goes on and like that. And then priority 4 and 5 are for those that are registering a very little, less than probably 50 a month. And then those are the ones that are really, we are not really, those will then be augmented at the outer years. Then in that case, we'll have to make sure that every child who then visit our mobile units, our health facilities, we will have to make sure that they are then screened, issued with the right document, so that they can be able to proceed with their lessons. Then there was a question by Honorable Lezel on the number of documentation that were issued for those that had to be issued with the records of birth. I must indicate, as Minister advised, we are not able to give a figure of the head right now, but what I can indicate is that most of our figures are quite manual, and we have to make sure that we consolidate all the numbers that are sitting in our outside offices. We'll make sure that we make a submission to the committee so that we then provide the exact number in that regard. Thanks so much, Chair.
Thank you, DDG Sigama. Advocate Rapeso.
Thank you, Chairperson. I'll start by the comments made by the Honorable Liesel van der Merwe on the process of endless appeals. Unfortunately, that is what our legislation provides, that a failed asylum seeker at the level of an RSDO level, they've got an option of whether to appeal to RASA or automatically be reviewed by SCRA. So as an administrator, RASA is prone to review processes. Upon an asylum seeker being rejected finally by RASA on appeal, they want to implore their chances with the courts by lodging a judicial review, which is the last leg of any asylum seeker. So I would say that in the past, the department would, upon them issuing the decision of a rejection, they would issue a 14-day permit within which they must wrap up their things and depart from the Republic. And the courts were not happy with that, to say this person has been in the Republic for a number of years and they can't wrap up their life, their entire life. They've been in South Africa in 14 days. So that as well created this unending ladder of appeals. But as it stands, this is our appeal process. They all go through it, whether economic migrants or not. We don't have any other legislation to deal with those. And how many economic migrants we have, the minister have already indicated, as well as Mr. Madumisa. We can't put a number on it. With us, RASA, it takes a hearing by a member to interrogate an asylum seeker and to finally determine if this is a refugee or this is an economic migrant. Other than that, you cannot, because the claim when it's made, somebody says, I'm an asylum seeker. And on the vacancies, the timeframes, we are shortlisting next week, Friday. We should have them on board by October, the 10 outstanding members to complete the number. And the issue of incomplete files, this is what I meant is that in the past, when the project started, we did not want to risk having incomplete files because we are an adjudication body. So the department is providing us this digitalization platform, and there is quality assurance, as Mr. Madumisa has indicated. And the files that we receive from them is those that we request from them, because as the asylum seekers are coming through to renew their Section 22 permit, we then issue them with a date for a hearing, and that will also lead to the department streaming the file right to RASA, because the systems are interlinked. Once we give you a date, then a file should be ready on the other side. And on the issue of reaching asylum seekers, we have devised means to get hold of asylum seekers, and we are seeing significant progress in getting hold of them as opposed to when the project started. Yes, it is a challenge, but we are working on it. As I explained, together with the department, we devised on a means to block the system where somebody doesn't come through to acknowledge their notice of hearing. So we know that they come, as an asylum seeker has to come through to extend their Section 22 permit. If you are then required to come and acknowledge receipt of your notice at RASA, you'll have to come by RASA first before the department extend that Section 22 permit for you. And that has proven that it's working and it's assisting to us. So I will also put this on record that in terms of the rules of court, We use what we call a domicilium executendi, whereby an asylum seeker would have used the contact details that he has provided us with, because in essence, it is a responsibility of an asylum seeker to obey the laws and the Constitution of South Africa, including informing the department at all times when their addresses or contact details change. So now we are working on a system where we are imploring to them and engaging with their community representatives for them to come through to RASA to give us their contact details. And yes, they are coming in numbers. We get calls, we get emails. Asylum seekers are coming through to give us their new contact details. So that as well is working. And I'll move to Honorable Ruo's comments. He also tapped on the issue of contact details, and that we should know where they are at any particular point. I've already responded to that. And I heard him say a new backlog on new applications. I'm not sure if he's referring to RASA or to the RRO slides, but in terms of RASA, I'll repeat, with the new backlog, we don't have a new backlog as yet, but the new application, the new appeals that we will be receiving will designate some members to deal with the new appeals that are coming through for us to avoid a recurring backlog when we are done with this one. And Honorable Ruos also asked if we are going to complete the backlog project in 4 years. We are hopeful. We are hopeful that now that the obstacles that created backlog, a bottleneck for us are out of the way, we should be able to move speedily in order to finalize the backlog. We are trying our level best. I believe with the recruitment of the outstanding members, we should be able to forge ahead. And with regard to the stats, a comment raised by Honorable Pillay on the slow progress. Yes, at the beginning, maybe it seemed like the slow progress because of the challenges that I've outlined, but now we are seeing progress. Now where I'm sitting, I've got 20 decisions that I've received from yesterday that I need to review. So there's a process of review where we assist members to see if the decisions are that of quality, because remember, these members were not afraid with the refugees and migration regime. They're in the process of training. So up until a time comes whereby they can just independently fly on their own. So we've embarked on this process so that we don't make mistakes whereby we don't grant asylum to deserving refugees and whereby people who are not deserving are granted status. So that is a progress. So now things are looking good, the systems are looking good, the department is assisting with the systems, UNHCR as well, they are on board, we are offering trainings now and then, we identify where members lack training because we also brief them along the way. So it's a joint thing. So where we see lack, we come and then offer training. Where we see a trend going on, and then we then come together with the UNHCR and then we give training on that point and so forth. So I'm hopeful that now in the future, we will be able to see a great improvement as most of the hurdles are out of the way. Thank you.
Thank you, Advocate Rapeshu. Minister DG, start with the DG. DG, if there's any other matter?
No, thanks, Chair, and thanks. Good morning, Honorable Minister, Deputy Minister, Honorable members. Just to emphasize a point that the Chief Director, Asylum Seeker Management made. Honorable Ross, you will recall that with regards to the Cape Town Refugee Center, there's a very clear timetable that has been set by Judge Devet with regards to the reopening of the center. And on the 20th of July, 2022, she visited the center We also visited the center with her, and then the DM was there a week ago to monitor again the progress that we are making. As the Chief Director indicated, the site is being handed over to us at the end of September to make sure that we then finalize with the installations. I just thought I should re-emphasize that point. But overall, thank you so much. Thank you.
Thank you. DM, is there another matter we may need to raise?
No, thank you, Chair. Just to confirm the statement made by the DG in terms of the Cape Town Refugee Reception Center, it's actually a very good model, Chair, that we need to look at in terms of our office footprint, because it relies on the risk being placed with the owner to complete renovations and set up the offices so that they are in good shape. So it's quite a very good and interesting model that we really need to investigate a bit more for our civic offices as well. In terms of the question that was asked by Honorable Ross, in terms of what are we doing to ensure that we promote early birth registration, we have just recently came back from 3 of Izimbizo to go around the country and promote early birth registration and to urge parents to make sure that they register their children within 30 days. This does not mean that after the 30 days, we no longer register the children. Yes, we do register them, even though it takes a bit longer. You will notice in terms of statistics that almost about 840,000 are now early birth registration out of a total of about 1 million births that we register almost every year, which shows that we are making progress in terms of diverting more children to be registered within the period of 30 days, which is early birth registration. One of the projects that we took up when we came into office in 2019 was the issue of making sure that we expand our footprint in terms of presence in hospitals. And that has helped us increase our early birth registration figures. Yes, we were interrupted with COVID, which limited our self-funding financing activities in order to roll it out to more hospitals. But as the situation is improving, we'll continue with that project to make sure that we increase the footprint. Now, one of the things that we have picked up, because when we go to those Izimbisos and interact with the communities, it gives us a picture of what is happening on the ground and what becomes the root causes of late birth registration. Is the issue of unpresent parents and unpresent fathers that we need to deal with, where a child is just left alone at home with a granny and the mother then disappears. That is the biggest challenge that we have with late birth registration, where you meet an 18-year-old person because the mother or the father was not there from the beginning to make sure that the birth of the child is registered. So it means we must then divert our campaigns to say, make sure that even if you are going to leave the child with a grandmother or a grandfather or an auntie or where you are living, make sure as a parent that that particular child has a birth certificate so that at least even in the future, it does not become difficult to then convert them. On the issues of refugees and asylum seekers, there is one point that I think we need to emphasize also at a level of the portfolio committee and in terms of our language. The issue of sending countries dealing with adverse drivers of immigration. Countries of origin and countries that are sending countries in terms of asylum seekers, because people become asylum seekers because they are either human rights issues, there are issues of abuse and so on, subtracting the ones that will be economic migrants. So if countries of origin can also bear the responsibility of making sure that they deal with these adverse drivers that are pushing people away out of their countries, so that migration becomes voluntary but not forced on the basis of the economic as well as social conditions of that particular country. I think if we can start speaking more about that, we are also going to be contributing in dealing with the problem that we face. Those are the few comments I wanted to make, Chair. Thank you very much.
Thank you very much, Deputy Minister. Minister?
Thank you very much, sir. I think most of the questions have been answered. I will just touch up a few. Honorable van der Merwe, I'm sure now you appreciate our program of digitization, how important it is, so that we have got digitized records, and organization like RASA doesn't have to go through what we are going through. Remember, it's not only RASA, it's even the civics, where people have to amend their age, their date of birth, and their marriages. Is always a nightmare. The second question, which is very important, Honorable van der Merwe, the issue of unending appeals. You ask a question, whether legislation will ever change it. Honorable Ruas asked it differently. He said, can we change the law to deal with the appeal process? Yes, indeed. That's what we are doing, Chairperson. If you look at the various statements we've made, and even the comments that were made by the committee led by Dr. Lubisi, which were reviewing permits and visas, they are actually emphasizing on this issue of changing the laws. That's why we're saying the whole immigration system needs to be overhauled. This statement, which Honorable, Advocate Drapesu made, was made to her by a judge who said the government has created a bureaucratic ladder and let the people climb on it, meaning this bureaucratic ladder of appeals and appeals. This is why, Honorable van der Merwe, if you remember, the people who were holed up in the church, in the Methodist church, in central Cape Town, there were ringleaders in that. One of them was Aline Pakuru, the other was Papi Sakumi, and the other was Jean-Pierre Palus, who is still in jail now, waiting trial. The first two were deported after 13 years, after appearing in front of a magistrate. For the whole 13 years, they were climbing this bureaucratic ladder. And you are aware that eventually it was proven that they don't need any international protection. They were just using the bureaucratic ladder because it's there. Papi Sakumi actually proved it. Immediately after eventually the magistrate agreed that he be deported. When he arrived back in the DRC, he formed a political party and tweeted internationally for us to see that he was actually fooling us. He tweeted that he's back home and has formed a political party. I'm sure all of you are aware that a human being who needed international protection cannot go back to the country where they ran away from and even form a political party. They will be arrested immediately on arrival. So it just proves that our bureaucratic ladder doesn't help anybody. It just complicates our life. That's why we're going to change it. Honorable van der Merwe, I wish to thank you profusely for noting that I've been accused for something that is definitely unfounded. I'm not sure whether it's manifestly unfounded or just unfounded, but thank you for noticing that. Sometimes you just try to develop a thick skin because missiles are thrown against you for reasons that are unknown. But I'm very happy that you realized, and I'm sure Honorable Pire also said it, that there is nothing wrong I'm doing. What I'm doing, Chairperson, and I won't apologize for that, I'm applying the laws of the country without fear, without favor, and without prejudice. Where I'm misapplying the law, there are remedies available within the South African legal system, which is one of the strongest around the world, as is known. So I will definitely follow those laws. Honorable Ruas, you mentioned the issue of whether I must confirm that there's no backlog on new applications. Yes, the present backlog was dealing with is about appeals, climbing this bureaucratic ladder that was mentioned by an honorable judge. That was it. If we develop any backlog on new applications, it will be after COVID, but it won't be something that we're unable to deal with. It won't be something that will be so difficult for us as to establish the type of process that we have established with United Nations. The issue of verification by whether there is an e-system. Indeed, Honorable Ruas, Yusuf has actually answered it, that the police did not have to put somebody in jail for the whole weekend, waiting for Home Affairs to verify. I'll remind you that we also have a similar problem after the incidents at Diepsloot, where there was a big uproar and some journalists called me whether there must be a national dialogue about whether immigration officers or police can ask for anybody for documentation. And they actually ambushed the president, who was asked that we are using an old apartheid method, because one police person asked somebody to name an elbow in Setsonga to see if they are South Africans. Now, those are not our policies, Chairperson. We actually do have a 2010 legacy project whereby police have got the right to stop anybody and ask them about documentation. It doesn't have to be production of physical documentation like during apartheid days. It means you are not forced to run with documents in your pockets, but you can be checked here and there if they found that 24-hour system which you have. And we believe all our law enforcement officers must know that, just so that we check you immediately on the National Population Register or on the NIIS. It's something that can be done on the spot. It's a pity if somebody had to be arrested for Home Affairs officials to come and verify documents manually. It should not happen that way. On the issue of whether the backlog, Honorable Gross, will be completed in 4 years, that is the plan, and we are monitoring it.
No. Minister.
Yes.
Mr. Salmon.
They're muted, Chair.
Okay. Thank you, Mr. Apologies. Proceed.
Yes, we are really trying our best to complete this backlog in 4 years, but because we are monitoring it very closely, if we realize that somehow we are going to fail in the 4 years, we will try to amend accordingly. But our plan is to really complete it within 4 years. Now, the Deputy Minister has clearly outlined the problems we experience when we document people, even South Africans, and that we have opened offices in hospitals to try and deal that, and we are moving around with mobiles. But I want honorable members to appreciate some of the social problems, and I'm not giving an excuse, I'm just giving you what's happening socially when we have to document people, as the Deputy Minister have said. I once went to El Dorado, where we went with mobiles, and lots of people came, large numbers, showing that the service is needed. One of the boys who came there was a 14-year-old boy who has won, I don't know whether it's a scholarship or a competition, to the US for soccer. He was a star at 14, but he couldn't leave because he didn't have a passport, because the mother could not be found. The people who approached me felt so bad for his future that I instructed the police and social workers and immigration officers who were there to go and look for the mother, who is on alcohol. They searched the whole of El Dorado Park, they found her. They brought her in to help the young man to get the passport. And while she was on the queue, just when we looked the other side, she disappeared completely, and she was nowhere to be found. And that kid was sitting there and crying. And in this case, we have got to call social workers again. So we do meet many of these instances where kids cannot be documented, cannot get their documents just because parents don't care, or parents have got particular social problems like alcoholism, like being on drugs, and they just disappear. It's a very big social problem, but we are trying our best to deal with it. The last one, Honorable Pile. Yes, thank you very much also for noting that I was accused for something that is unfounded, Honorable Pile. The issue of ambassadors helping their nationals to get birth certificate is also one of the issues we raised with in the high-level meeting with the Deputy Commissioner for Protection. And one of the 6, if not 7 agreements we made was that the United Nations will convene a meeting of all ambassadors who are in South Africa to discuss this matter with them and show that at some stage or the other, they ought also to take responsibility for their nationals, not just to put the burden on the shoulders of South Africa only. They also have a role to play, like somebody who comes with a record of birth and asking for a birth certificate, a birth certificate of their country. Ambassador needs to help in that regard. I'm still waiting for the United Nations to convene such a meeting, which we'll appreciate very much. Otherwise, thank you very much, Chairperson. Thank you.
Thank you, Minister. Thanks very much. I will invite Mr. Jesus Perez, if there are comments to round up. Mr. Any other matter you want to raise?
Honorable Chairperson, I'm not sure if Jesus is connected, but I think with a question referred to us by Honorable Brandon Pillay and also mentioned by Dr. Matsoledim, I want to say that indeed during high-level dialogue, it was a discussion regarding involvement of ambassadors and a view of documentation of newborn babies or their citizens. I can say that we remain committed, and UNHCR is discussing with Bureau because SAMCO, UNHCR SAMCO is covering 9 countries. Bureau, it's covering more. So we are in discussion with regional bureau to organize such a meeting and to discuss issues pertaining to documentation of children and documentation of person, especially like it was mentioned during this discussion. We're dealing also with a number of persons abusing the refugee system. And, you know, like last resort, they entering in an asylum system to cover their legal stay in South Africa. So from one side, this is one phenomenon which is happening. From other side, if they are genuine person who are protected by South Africa, this may put some difficulties in terms of approaching some of embassies or their embassies to document because they are asking international protection. But in any case, a meeting will take place. I hope we'll agree with Bureau when to do it, maybe before the end of the year. And I think this is the main question which we had on statelessness. But also just to mention on the same view, we had a meeting with authorities, with Director General from Home Affairs who participated, and it was a national plan put in discussion. So we'll continue to have this dialogue. And to in terms of documentation, I will appreciate and I will thank Home Affairs and Honorable Minister and the colleagues from Departments of Home Affairs for good interaction on documenting and those who want to return home for voluntary repatriation. And I can report to you on this forum that by now we together repatriated 168 persons to DRC, to Kinshasa and Lubumbashi. And we have the plan and discussing now with Burundi office to repatriate. We have a list of 200, 250 persons who wish to return back home. So for such type of person who are voluntarily going back home and applying for voluntary repatriation, there are no any problems to document and return them back. Thank you very much. Over to you, Chairperson.
No, thanks very much for the response. I'm also will be struggling with the load shedding. If I cut off, I'll request Honorable Pillay to assist the meeting. We're stepping off this item, and I want to appreciate all the good work, progress identified on the presentation that we made, and also collaborations with the stakeholders in the Home Affairs, and also thank Minister for also the entire team for having gave progress in terms of the work that is being put, and advocate for your new role. We must also take this time to congratulate you. It's evident that at least there's a progress to that extent. That also some of the issues that may have came out that may not have been properly being responded. I think you must take notes around those issues. We'll be monitoring those, following up on some of the issues that are being raised and some of the issues that members continue to raise. We'll also do, Minister, a walk in some of refugee centers, just to observe issues that were presented for our attention. So members will work in your institution to make sure that in the next meeting when we come, we also ascertain the good work or the weaknesses that we might have identified. Turnaround time is critical if we want to perfect our efficiency. But I think we're confident in the manner that the presentation has been responded. I've noticed that there are some of the issues that were raised on the chart, and I think Advocate and the Minister will take them and will be responded to in our engagement forward. Was stepping off this item, and thank very much. We did step off the item, the first item, when we dealt with the civil society of Congolese. We noted the report, we referred it to the portfolio committee, to the Home Affairs. We're also noting the reports that have been presented by the Minister and his team. We'll then establish a tracking for update on some of the issues that the committee is interested in, society and all who are interested on the matter, but also to make sure that we assist our people in our service delivery work. We'll then step off this item, invite Mr. Salmon to give brief on the report, Electoral Amendment, and then I'm sure that in attendance here is the State Law Advisor, if they're here, and Parliamentary Legal Service, and the Council Advocate BA and your team. I'm sure the IEC, they're in attendance, but that is the brief of what came out of the submissions. And Mr. Solomon will give us a brief and outline on how we'll deal with the matter, and we have to conclude this matter. Then we'll formulate the process forward. Mr. Solomon?
Thank you, Chairperson. Yes, presented here is a summary of the submissions that were received up until Friday afternoon. In total, there were a total of 256 submissions, of which 254 were email submissions and 3 were hand-delivered submissions. Of the emails, there were 231 short emails via the advocacy group EASA, excluding 23 duplicates. The 11 substantive emails comprised 68 pages of inputs, and they were physically delivered submissions from civil society, which had 1,218 signatures, and Defend Our Democracy, which was supported by 56 organizations. This was also submitted by email. In addition, Dear South Africa resubmitted its 5,500 submission supporters in a large bound document on the initial bill. There were also 3 emails and 1 substantive submission from COSATU that we received after the closing date, which I haven't had time to consider, and which the committee can indicate whether we should consider or not, because everybody else met the deadline, but these organizations, this organization and 3 short submissions were admitted late. In alphabetical order, Chairperson, I'll briefly go through the 10 substantive submissions, which I've tried to make as short as possible, given the short amount of time I've had to process them. The first of which is the 70s group, which did give us oral presentations in the first round of submissions. They indicated that the proposed amendments could be open to litigation challenges, in that the initial submissions were ignored, and that the drafters of the current bill were leading us to an unconstitutional impasse, because the research that they did was ignored, and particularly their support for the majority view in the ministerial review panel on elections. The Center for Societal Advancement are particularly in favor of the using of the words partisan versus non-partisan candidates, rather than political versus non-political candidates or independent candidates. They say this because partisan or political party candidates are supported by their political parties, whereas non-partisan candidates are not supported in the same way. And so the terminology independent candidates in the A list of the bill suggests that these candidates on their own and do not need support. It further names them in relation to being independent of political parties, as if the political rights accruing to all citizens can only be enjoyed and exercised when one is associated with the political party. The vocabulary must change to refer to non-partisan and partisan candidates at the provincial and national levels, and should only refer to independent candidates when dealing with local municipalities. Otherwise, no ordinary citizen can become a seriously contending candidate at provincial and national levels without at least two things. The first of which is administrative support by their partisan associations or non-partisan associations, called by whichever name. And the political parties in this regard should play on even playing fields, because they are the products of the provisions of Section 18 of the Constitution, applying to all citizens equally. And that candidates also need manageable constituencies within which the candidates are known to citizens who will vote for them, thereby enhancing accountability once elected, and that district municipality levels are more sensible constituencies to be adopted for this purpose, rather than the provincial level proposed in the current revised bill. And then they also object to the insertion of the word person to mean natural person, but instead propose that the word citizen should be used. This is echoed by a number of other submissions. Secondly, that the person that contests the elections is the candidate. The current legislation refers to citizens as candidates only when they are identified by a political party, and independent candidates when they are not from political parties. This could arise in potential discrimination, they say, where non-partisan candidates are in some way less entitled than partisan candidates or political parties. They reject to the insertion of political liaison committee on the basis of the Constitutional Court judgment which gave rise to the judgment, in that it doesn't do away with political parties because they are a product of the enjoyment of Section 18 of the Constitution, and that the insertion should rather read party liaison committee and or non-partisan liaison committee. The effect of this should be that the electorate is now introduced to two types of candidates to be voted for, and as indicated. Next, they indicate that Amendment to 31A of the bill should allow independent candidates to contest more than one region for a seat in the NA, and that this should be facilitated by improving administrative support. which is currently only provided to political parties. And so the question is, how can this administrative support be extended to non-partisan candidates? And so that a new clause and definition should create recognition, provision, and promotion of administrative backup to non-partisan candidates, as well as being inserted into the bill. So this organization is pretty much in favor of providing formal provisions for the administrative support of non-partisan, or as otherwise known as independent candidates. The objection to regions, which we submit, is formed by the fact that the bill recognizes provinces as regions. This arrangement disadvantages non-partisan candidates, because without their associations being recognized, they're best known around their wards, local municipalities, or district municipalities, and not at the provincial level. Multi-party democracy also means rejecting the substitution of party for political, because this is confusing, because the concept of political parties should also come with the recognition of the non-partisan associations in the same way that political party support is recognized. There's a need for separate requirement or qualification for non-partisan. There's no need for separate requirements for qualifications for non-partisan candidates, as this could be perceived as unfair discrimination, and which would also be solved if the non-partisan candidate support systems were recognized. The unfair discrimination referred to in A, C, D, and F of the advert calling for submissions has reached its zenith in asking political candidates with no associative backing to now go to the voters twice, first to secure signatures and secondly to ask them to vote for them. And this is similar in instances of I, J, K, and L in the advert calling for submissions. Is a further form of discrimination. And so in order for non-partisan candidates or independent candidates to fully exercise their rights, they should have their supporting organizations recognized. And this should include compensatory seats and all proportional representation allocations where votes for non-partisan candidates will compensate for non-partisan associations. Particularly when it's known that political parties represent only 1% of the population in terms of actual support numbers, membership numbers, and that by allowing 50% of the seats as suggested in the bill, this could arise in exclusivity rather than representativity. And B, the counting of votes and the compensatory votes applicable to political parties must be exactly the same for non-partisan associations. Citizens Parliament, they indicate that 31A of the bill, allowing independent candidates to contest more than one constituency seat, strongly recommend that the district sorry, is there somebody no, okay. It's strongly recommended the current district municipalities and metros be recognized as constitutional constituency districts for provincial legislatures and the NA. They indicated the deletion of references to political parties is unconstitutional in terms of section 19 and 18 of the Constitution, and that the removal of qualifications from 31B is inconsistent with section 3.2a and section 9 of the Equality Clause of the Constitution. This means that political parties must meet the same qualifications of 30% for a seat for registration to contest elections. And if political parties only need 1,000 signatures, then this should also apply to independent candidates. 31.3b and 6, they indicate that no monetary requirement should be required for qualification and or contesting elections. because this would allow for interference and fraud by private sector and private interests. The bill also retains the existing voting allocation system as contained in the Electoral Act, using the highest remainder system. But they indicate that political and non-partisan associations should be treated equally in the remainder of votes, and independent candidates be counted in favor of the non-partisan associations. There should be an official arrangement before elections on how non-partisan candidates share their remainder votes and their right to collaborate in advance with their respective constituencies. And the bill also provides that independent candidates contesting in one more region cannot aggravate their votes. The proposed recognition of the current municipality districts and metros as constituency districts would solve this problem if properly administrated, they indicate. Civil society. So this was an organization which got 1,218 signatures, which were physically delivered to Parliament. And it comprises the following. They indicate that we, the people, call to consider amending the bill to be fully representative and take us to an electoral system where our representatives act in the best interest of all the decisions that they make. They call upon Parliament to ensure that we're able to vote for independent candidates in the national elections in 2024, to move quickly, to allow candidates to be able to contest for all 400 seats, and for the votes of independent candidates not to be given to political parties, but rather distributed amongst independents. And that any bill that fails to do so is a violation of the Constitution and true democracy. And that independent candidates should be defined as a natural person or community-based association and movements. They reject that candidates must be required to have 30% of the seat quota in signatures in order to be eligible to contest. And this is an onerous burden placed on candidates in an unfair environment. They call upon a clear and fair deposit amount to be prescribed in the Act so that to prevent independents from being denied their electoral rights. And that hundreds of thousands of rands or even 10,000 of rand is unfair. They reject as undemocratic that vacancies are filled by recalculation, and that in the event of death or sickness, a member of Parliament must be elected via by-election. And they reject the limitation of votes to one region. If a candidate has 100,000 votes nationally, they should deserve a seat in Parliament more than a political party with only 75,000 votes. Defend our democracy. This was supported by 56 organizations, which are listed below. On 2 September 2022, they held an Indaba with My Vote Counts, Rivonia Circle, Ahmed Kader Foundation, and Defend Our Democracy in Johannesburg. And they indicated the bill is flawed. The fundamental problem with the current electoral system is that members of Parliament are not chosen directly the people. We want a system which allows the electorate to directly elect representatives to be able to directly hold them accountable. Moreover, the bill ignores the findings of the various reports, the Van Slees-Sabbat report, the 2006 Parliament Briggs Govender report, the Kalema Mutlanta High Level Commission, and this year's Zondo Commission report. With that in mind, the civil societies represented at the Indaba support for Parliament to reshape the electoral system in the interest of the public in a way that is credible, fair, and inclusive, and that promotes greater public accountability. They outlined why the majority view of the Ministerial Advisory Committee should be considered as the minimum basis for changing the electoral system and should not be ignored. Otherwise, it will be subject to legal challenge. As the bill stands, the system that it proposes has not been tested anywhere else in the world, and it's complex and will not result in proportional representation. It goes against the underpinning of the democratic and constitutionally prescribed principle of equality, where every person's vote is of equal value. by privileging political parties and further disadvantaging independent candidates by making them compete on unequal footing. They urge the committee to consider a mixed constituency and proportional representation list system at the national and provincial level that includes the right of independent candidates to contest elections on equal footing. Given the short timeframes, there's an urgent need to find a consensus going forward. They then quote Nelson Mandela, who indicated that we need to ask whether we must re-examine our electoral system so as to improve the nature of our relationship as public representatives with voters. The opportunity for meaningful electoral change should now not be missed by society at large, nor dismissed by political role players. The 56 organizations supporting this, including some of the others mentioned in this submission, are listed here. The Independent Candidates Association, ICA, that indicate that by them commenting on the bill, they in no way endorse the bill in its current form and that it's fundamentally flawed. And they also support the majority view in the Ministerial Advisory Committee. And they support the private members' bill of Honorable Lekota, as well as the electoral report submitted by Inclusive Society. The Inclusive Society report advocated the interim measure of a district model of 66 constituencies, which do not need demarcation board intervention. And they also support a 4-ballot system to make the bill constitutionally compliant. Clause 31B(3)(8) dealing with signatures ensures that vacancies that have been created by independents are filled by recalculation. And the current amendment bill fails to pass the constitutional test in that clauses, as stated, fulfill the sentiment of the vote of each and every citizen is a badge of dignity and personhood. Quite literally, that every vote counts. Relating to aggregated votes, 31A of the bill states that a person must be nominated to contest an election as an independent candidate in one or more regions of the National Assembly, but may be elected to only one seat in the National Assembly. The result is that this amendment is that an independent candidate can contest in more than one region. The above portion must be read together with 57A of the Schedule 1A, which indicates that a candidate may be nominated as an independent candidate in more than one region. And that where an independent candidate is contesting in more than one region, the votes received across the region may not be aggregated. The result of this is an amendment that independent candidates contesting in more than one region cannot aggregate their votes. We believe this is unconstitutional because, firstly, it prevents independent candidates from meeting the requisite vote threshold or quota in order to be allocated a seat by limiting the votes considered to one region, despite the fact that if the total votes across the regions were aggregated, an independent candidate may meet the quota. This violates the proportionality requirement. And secondly, it is arbitrarily discriminating against independent candidates compared to political parties, who may compete both for regional and compensatory seats. Stated specifically in 57A, the number of seats to be awarded to a party for the purpose of the paragraph D must subject be determined by dividing the total number of votes cast in both regional and compensatory ballots in favor of such a party. Therefore, political parties may be awarded seats based on all votes received, but not independent candidates, violating the proportionality requirement. In terms of compensatory seats, the seats in the National Assembly are determined in terms of Section 46 of the Constitution and Schedule 3. Half the seats are filled by independent candidates, half the seats are filled by candidates from lists by parties. The result of this clause is that independent candidates are only allowed to compete for half of the seats in the NA. Independent candidates cannot compete for compensatory seats. The result of this is twofold. Firstly, the votes cast for independent candidates are outright precluded from being proportionally translated into seats. as independent candidates may only stand for half the seats, and therefore the total 400 seats in the NA will never reflect the total votes cast, whether for independents or parties. Secondly, this has an effect on the quota for the independent candidates to be allocated a seat, which equals the votes cast divided by 200 plus 1, versus the quotas for party, which equals 400 minus 1. This calculation is apparent in clauses 57A, which sets out the allocation for regional seats. And then this goes into more detail around that. Accordingly, the quota for an independent candidate can be awarded to a seat is higher than for a political party. This violates the right to equality. The effect of this can be demonstrated in the following. The effect may seen in the table below, which indicates that independent candidates can only stand for half the seats, combined with the fact that independent candidates' quota to allocate the seat is higher than that for political parties. The example shows that that party A received only 54% of the votes, but 59% of the seats. Therefore, it received more seats than votes. Comparatively, independent 1 received 5% of the votes. They received only 1 seat, while party C received less than independent 4 at 3.3, it was allocated 2 seats. This not only violates proportionality, but also the calculation of seats in the NA. In terms of surplus seats, 57A of Schedule 7A of the bill provides that the NA independent candidates may be allocated regional surplus seats. Therefore, they may be allocated a surplus seat despite not originally meeting the seat quota. This allocation will take place by allocating a surplus seat in the sequence of the highest surplus. However, allocating compensatory seats for which only political parties may compete in terms of 57A provides that all votes received by political parties will be totaled and all votes by independent candidates will be deducted. Therefore, the quota for seat allocation and surplus seat allocation will be less than for regional seats. And that violates by proportionality by not translating votes into seats. In terms of provincial legislature, 57A12 deals with the allocation of surplus seats. If an independent candidate has been allocated more than 1 seat in a province, he or she will be allocated 1 seat and forfeits any additional seats. This item proceeds to calculate where the additional seats go. The effects of this calculation is that ultimately they go to political parties. This may be demonstrated by utilizing the 2019 provincial Gauteng legislature votes. And the scenario 8 independent candidates stand and they receive 10% of the votes. The table demonstrates that while, for instance, the Freedom Front received less votes than the independent candidate 1, it was allocated 3 seats, while the independent candidate was allocated, whilst independent candidate was only allocated 7 seats. Therefore, the votes received do not translate into seats. And the combined ballot in 57A6 states that a quota of votes per seat must be determined by dividing the total number of valid votes for parties in both regional and compensatory by the total number of seats in the National Assembly plus 1, minus seats won by independent candidates. The result plus 1 disregarding fractions is the quota for the seats. And the bill also provides for 3 ballot papers, 2 for the NA and 1 for the provincial legislature. The above clause provides that votes cast in the regional and compensatory ballots are counted together in order to determine the quota to allocate seats. The result of this is that the NA parties will be allocated more seats than they would if they had 2 ballots counted separately. If the votes cast in the 2 ballots were counted separately, the votes would be allocated more proportionally. And this may be demonstrated this is demonstrated in the following table, where independent candidates received 10% of the regional votes and were allocated 14 seats, while political parties received 50% of the regional votes and 51% of the compensatory seats, and ultimately were allocated 386 seats. Therefore, in example A and C, would have been allocated 195 seats if the two ballots were counted separately, but they were counted 203 seats by combining the ballots. And the combination of the two ballots does not affect the seats allocated to independent candidates. This therefore is disproportionate in favor of political parties. The submission from the Institute for Race Relations basically indicates that there are significant changes in the bill, and that this requires an additional public participation, and they, through their lawyers, indicate that the time allocated was not sufficient, and they request an additional 3 weeks, and that further communication on the call for submissions be submitted. Bearing this in mind, there were nonetheless significant amounts of submissions and signatures received from various parties. Michael Atkins is an independent expert on elections, and he gives a number of technical submissions on the bill. The first of which is that the recalculation of seats set out by items 7 and 12 is defective in that it is biased in favor of larger political parties, as mentioned in the previous submission, and has the unintended consequence of transferring a seat from a smaller party to a larger party. This is because the recalculation always follows a standard allocation of quota and remainder seats, and then the removal of one or more seats. If the seats are removed and the quota recalculated, then the quota will always be lower than it was previously. Reducing the quota means that the number of votes required per seat is reduced, which provides a benefit to parties with quota seats. Crucially, this benefit is also multiplied by the number of quota seats held, obviously then benefiting the larger parties the most. They indicate that the IEC incorrectly advised the committee at the time that the error would not apply to existing item 7 recalculations. But the IEC disregarded the input given by that the recalculations inherently benefit political larger parties. Secondly, a second ballot for provincial legislatures causes the results to be disproportional, violating Section 105 of the Constitution. The altered seat allocation calculation maintains the disproportionality. The underlying logical problem of individuals being listed on the same ballot as parties in a proportional representation election cannot be cured. Minor changes can be made to the seat allocation mechanism, which can partly mitigate the numerical effects. But this does not remove the principle of disproportionality or the effect of votes cast in favor of independent candidates. The inclusion, thirdly, of regional ballots in the PR calculations for the National Assembly violates Section 46 of the Constitution in general proportional representation and Section 19 on the right to fair elections. The remedy is straightforward. After calculating the seat allocations for elections in regions, and after any of the 400 seats of the National Assembly are allocated to independent candidates, the PR calculations for the rest of the 400 seats should be carried out entirely on the basis of the separate PR vote, a PR ballot. And D, the excessively high signature requirement for independent candidates is unreasonable and unfair and entirely out of proportion with the requirements for political parties. For example, the National Assembly, the 4,400 wards compared to 400 seats, the signature requirement would only be 600. Even a signature requirement of 1,000 would be reasonable. Anything more would be repugnant. Allowing independent candidates to contest multiple elections disenfranchises voters and creates disproportionality in terms of the Constitution, with a bias towards larger political parties, and also Section 19 of right to fair elections. Since the voter may not be aware that a particular candidate is standing or has a reasonable prospect of success in another election, or they might prefer that candidate if they knew the prospect of the candidate being elected elsewhere, then it is reasonable to assume that they might vote for somebody else. The second major problem is that the removal of votes and the calculation carried out in terms of section or items 7 and 12 of Schedule 1A will inevitably create numerical distortions of proportionality. And it's logically possible that the recalculation executed in terms of the successful independent candidate for fitting a seat will have the effect of transferring a seat from a smaller party to a larger party. And then there's another technical challenge which they indicate in relation to this. And then, yeah, so these are more technical related to the same matter. And then F, the method for filling vacancies relies on defective recalculation methods that is unnecessarily complicated and that has built-in bias in favor of large parties, violating Section 19 of the Constitution on fair elections. And there are several logic and drafting errors, primarily on Schedule 1A. And the quota in the signature requirement refers to a figure that is substantially higher than that assumed to apply, being the quota for National Assembly. The remedy is simple, that vacancies can be filled by using the original seat allocation calculations and allocating the seats to the party or candidate with the highest remainder out of the parties and candidates that have not yet secured a remainder seat. This is awarding the seat to the next on the list of remainders. Next, and we're almost done, is the New Nation movement. Looking in the amendment and the bill as it stands, it's clear that the bill is focusing on the inclusion of independent candidates, but very little on the right of the citizen to associate without being in or joining or forming a political party. Their initial submission was that the spirit of the judgment of the Constitutional Court was the inclusion of citizens' assemblies, associations. And as the initial litigants in the Constitutional Court, they respect the committee's decision to ignore this, but not without protest. There are the following areas that they offer suggestions in. The insertion of the definition of person to mean natural person, whereas the Concord refers to citizens, and they indicate they support this inclusion rather. On the point C of the advert, they propose that the declaration must be signed by the duly authorized representative of the party or citizen assembly or association, confirming that each candidate appearing on the party or citizen assembly's provincial list of candidates is registered to vote within the province in which their election will take place. And point D, the amendment to 31A of the bill to allow independent candidates or associations to contest in more than one region in the NA. They recommend that, like other submissions, the existing 52 district municipalities be used as the constituencies rather than provincial. This will save time and taxpayers' money. They were also already used for the determination of the seats in the NA and provincial legislatures. On point P1, the bill now retains the existing voting system as contained in the Electoral Act and extends it to independent candidates. It is correct that the electoral reform as instructed by the Concord should include independent candidates, but it's not limited to the inclusion of independent candidates. Provisions should be made for citizens' assemblies or associations to exercise their positive right to freedom of association. If this process fails to deal with this critical matter, it will open itself to unnecessary litigation. Needs be citizens will have to be given a right to say on this matter via referendum. And we propose that the seat must belong to a constituency district deep in the accountability structures and avoid having to have by-elections when something happens to a citizen assembly representatives. So again, this is the third submission indicating needing specific support for the associations or assemblies that support independent candidates or non-partisan candidates. One, South Africa. They indicate that they do not support the amendment bill, and based on the fact that it's also the minority report of the Minister of Advisory Committee. And it is important to incorporate independent candidates more meaningfully without introducing, you can't incorporate independent candidates meaningfully without introducing a constituency-based system. They also indicate that the signature requirement is too high, and currently as stands would require 12,900 signatures for independent candidates. And the constitutional issue is that political parties need only 1,000 signatures and compared to 12,000 signatures for independent candidates. And this is unfair discrimination. If the intention for the signature threshold that the ballot is not convoluted with candidates, they should apply across the board. And yeah, so basically the requirement for political parties is a ratio of 1 to 43, whereas the ratio for independent candidates is only 1 to 3, so significantly higher. On the issue of vacancies, that should be filled by recalculation in terms of the bill. The case in the Delil versus Speaker of the National Assembly indicate that suspension of a member of the National Assembly from Parliament for contempt is not consistent with the requirements of the representative democracy. It would be a punishment which is calculated to penalize not only the member in contempt, but also the party and those who in the electorate who voted for that party. The principle is to be derived from this is that the electorate are entitled to be represented in the National Assembly by their proportionate number of votes, and the bill proposes a recalculation that violates this principle. This is for this reason that we do not replace one political party with a different political party if the political party loses a seat, and for the same reason that we have by-elections. A vote is not numeric exercise that can merely be recalculated. For instance, the vote for the ANC is a vote against the DA and its policies. Therefore, it's unconscionable that a bill would propose a recalculation measure that could potentially result in an independent candidate being replaced by a political party. And we find ourselves in this situation because we did not follow a constituency-based system, and therefore regions that are too big to hold by-elections and find ourselves doing mental gymnastics and pitching unprecedented and constitutionally unsound solutions. And their recommendation is that there should be a running mate system where independent candidates can nominate a potential replacement before an election, and that the system enhances the values of openness and transparency. OUTA, Organization Undoing Tax Abuse, they indicated that there were several submissions from April until August for additional calling for additional public consultation, but that they specifically have issue with the following issues in the bill. D, relating to the point D in the advert calling for submissions, that candidates contesting more than one region in A, and that votes cast in regions not reaching the highest figure will be discarded. Such an approach limits the proportional representation by disregarding votes or discarding votes in favor of independent candidates, which is in contrast to the wish of the electorate when they cast their votes for regions. The concern here is that the signatures of voters who support a candidate containing 30% is a barrier to entry, as mentioned above. The votes and seats allocated to independent candidates who has vacated the seats will be discarded. Based on this calculation, the vacant seat is awarded to an eligible candidate or party. This means that the seat may go to a political party, and not with certainty to another independent candidate, as mentioned above again. Vusimuzi Nkema is an independent submission. He asked various questions rather than particular statements. And he asked in terms of Schedule 1A, Section 57A, are these constituencies that the legislation will create? How many are there in what district and within which district municipality? And why are the NCP seats not available to independent candidates? Is the Is it democratic that political parties can contest all the available seats, but independent candidates only half the seats? And the vacancy for independent candidates will be refilled by recalculation. Why not by by-election? On the forfeiture of seats, if registered parties have less than the required number of candidates listed, this is not democratic. Section 46(1)(d) of the Constitution states that our electoral system must result in proportionality. Does half the seats satisfy this in general proportionality? And does proportionality mean proportional to the votes received by the political parties only, not independent candidates as well? And lastly, the court made this minimum order, but with a broader view, and the Parliament chose to only attend to the minimum order. Among the act is to be in line with the current constitution as it is, and is not enough. Then, dear South Africa, just to indicate that I was only able to provide an overview of all the submissions, because there are 244 of them. I've asked dear South Africa to submit me their Excel spreadsheet, which analyzes in more detail the contents. But I've done an overview. I can provide more detail to members with a day or two more to analyze these results. But in general, of the 231 short emails, 221 or 95% were against the bill. And the main reason, by 70% of those 221 submissions, was against the bill in its entirety. 11% indicated they were against the bill because of the constitutionality issues. 6% indicated they had concerns around independent candidates, and 4% indicated the objections to the fact that there weren't broader electoral reforms. 6 were in favor of the bill, 4 due to independent candidates, and 2 due to other reasons. And 4 were not fully in favor, and 2 in terms of constitutionality, and 2 in terms of independent candidates' rights. So that's just an overview of the results. And as indicated, I haven't analyzed the COSATU submission because it was handed in late and I hadn't had time. And I will need more time to provide more detail on the Dear South Africa submission. For now, that is my submission, Chairperson. Thank you. Sorry if I went over time.
No, thanks, Adams, for your work to collate information or submissions, not me say information, submissions. And I think we must appreciate all those participated in the submissions. We must deal with a few issues for processing so that we're not outside the focus. One is that the closing date was on the 16th, if I recollect well, Mr. Salmon.
Yes, Chair. Yes, Chair.
And your reporting should talk to that and assist us to be firm on our process. That's the first point I think you need to deal with. Secondly, we're not starting public hearings. There are some of the issues as outlined on the advert that have been deliberated by the committee, informed by the submissions, oral public engagement, and the process which went into by the stakeholders we've been engaging with the Parliamentary Legal Service, State Law Advisor, the Council, which advised the Minister. And thirdly is that I fully agree that you just draw on all submissions and put into one space. What we need to do is to align those with what the committee has resolved to be a process to sort public submissions, which closed on the 16th of September. And I'm raising emphatic on this area so that we're able to be focused on the point which the committee has directed us to do for this extension of submissions. And I'm not suggesting to close any other view that is now being expressed in the meeting. At the time the committee had to deliberate, we must have those standard areas which the committee has dealt with and agreed to. It is clearer that we may not deliberate on the issues, and also noting that other members have already locked out due to network or traveling to the parliament that is starting now at 2 o'clock. The other point is that we're pressed for time, Mr. Salmon, and I think members also agrees that we're pressed for time so that we deal with this bill presented to Parliament, and the ONSOP must able also to have an opportunity to interface with the issues that may arise from stakeholders, political parties, or the community. I will suggest, so that we may not, because it's clearer that we may not take deliberations because of the issues I've highlighted. We may need to ask you, Mr. Salmon. Mr. Matonzi is also not on the platform. I'm not sure that he's back of the load shedding. To also consider if we can request an extra day to deal with this matter on deliberation, and get another day to work on the adoption for a purpose of the National Assembly. So I'm outlining this process to sort proper guidance and summary on how we're going to deal with, because we ought also to interact with the stakeholders I've mentioned, the IEC, Parliamentary Legal Service, State Law Advisor, the team that had advised the minister, so that we fairly look on the issues that are being raised. I'm not sure whether you want to come in before members, Mr. Salmon.
Yes, please, Chair.
Okay, you can proceed.
Just to indicate, Chairperson, that I have received an additional summary from Dear South Africa Now. And so I'll include that as part of my summary before I send it to members. And also to indicate that we have a provisional legislative program to deal with these submissions, whereby we meet with the stakeholders, the IEC, DHA, and Parliament Legal Services on Friday to respond to the submissions. So I'll provide a full summary of I'll provide the summary I provided today to members, with an additional summary of the Dear South Africa submissions tomorrow, and that the DHA will respond on Friday. Thank you, Chair.
Okay, I think let's assist the process, Mr. Salmon, and I want to be emphatic on it. We have opened and requested submissions on the 16th of September. And in your report, I indicated that if you come to the committee and say, Pillay Foundation or Ross Institute has submitted, has given us the submission on the 18th, and whether you know that we have requested submission to be on the 16th of September, you only account to the issues that has to do with the committee decision. So I wanted us to move from that premise so that we don't get many other issues that are coming outside the committee, and we get basic issues that we can manage. I think we must work on that one. We'll deal with this matter at the main core level, so that we don't deal with other issues which are outside what we've established as a principal process to engage on. Can I invite members to guide further comment, and then we we step off this item. I'll start with the Honorable Lizelle, if you are in, Honorable Mohale, Honorable Ruos, Honorable Ramulobeng, Honorable Pillay, Honorable Mudisimza. In that order, if members are still online. Honorable Lizelle. Okay, Honorable Lukhase. Honorable Morale. Okay, Honorable Ruos.
Thank you, Chair. Chair, yeah, I agree. I think it would be helpful for the summary to be aligned to the different areas of the changes. I know it's being presented as from Pillay, from Ruiz, etc., but I think it'll be very helpful if we say that these were the areas that changed, and these are the different comments on each one. I think it will definitely help us. But Chairperson, I agree with your proposed way forward. Thank you.
Okay, thank you, Honorable Ruas. Honorable Ramulobeng. Honorable Tito, if you have joined. Honorable Pillay.
Thank you very much, Chairperson. Chair, I think first I must concur and applaud you for the direction that is being taken, and you are clearly showing leadership. I want to support your proposal, Chair, in light of many things. One is time, two is that it's quite a lengthy presentation as well as many submissions, and it must allow for members to be able to go through it, understand it, and then be able to deliberate. But more so, Chair, I think in light of having to get this process to finality, we have to make sure that we stick to the clauses that we spoke about in this Electoral Amendment Bill. And that's in particular the process, Chair, just to clarify, was one that we were making substantive changes to the bill, and hence we called for written submissions. So we can't go back to the entire bill. We can only, zoom in and be specific around those specific amendments and clauses. And I think that's how it should be aligned, and that's how we should then be able to deliberate on that discussions. Thank you.
Okay, I think that is the approach we're going to take. Can I check if Mr. Njikela, you want to bite, and Ms. Gavenda? Parliamentary Legal Service? Okay. No, I think let's work on that one. Mr. Adams, Salmon, let's work on the date that be scheduled to interact with this report you have presented. And then let's make sure that members will inform them that are not in the meeting. And I think we've indicated that I'm moving to the House, which is sitting at 2, traveling and so forth and so on. And we'll then immediately convene MENCO, assist us to get MENCO in immediately tomorrow morning, so that we work on the scheduling and inform members in time. Is that will be sufficient, Mr. Salman?
Noted, Chair. Yes, we'll do as advised.
Yes, let's get the MENCO tomorrow morning at 8 o'clock so that we work on how we're going to facilitate scheduling of meetings on this item so that we're not going to confuse it with any other matter. I think we're done with this matter. We'll inform members. Thanks very much. Ministers, thanks very much. All the team that we presented invited to this portfolio committee. Is there any other matter that you want to announce, or you can carry announcement, Mr. Salmon from Mr. Matonze?
No, Chair.
Okay. Members, honorable members, thanks very much for this meeting, and the team invited stakeholders. We really appreciate, and we must appreciate those all who have made responses, submissions to this Electoral Amendment Bill. It's encouraging that our people paying attention to the current discourse. And I think we must appreciate that they're able to contribute to these issues that they're raising. And I think we're working on that clarity of that we're dealing with the issues that have been identified on the amendment, Electoral Amendment Bill. Thank you very much, members. The meeting stands adjourned.
Thank you, Chair.
Thank you, Chairperson.